Good morning, honorable members, honorable deputy minister, the leadership of the Road Accident Fund, colleagues from the Office of the Auditor General, from the Special Investigating Unit, and colleagues from Parliament. Thank you very much for being here. Today we are discussing the Road Accident Fund with the Department of Transport as well as the leadership of the Road Accident Fund. Firstly, I want to thank UDM and the Road Accident Fund team. So we are trying to make these conversations as focused as possible. So thank you for turning around the presentation, the document quickly, because we wanted to have the discussion with the Auditor General, and then, you know, as an outcome of that conversation, let you know more specifically what we want to discuss instead of having a long discussion that doesn't focus on specific things. So I hope it has been helpful, but I just want to thank you for turning it around and still being able to provide it on time to us. We really appreciate that. The members have had the opportunity to go through the document. So what we are encouraging everyone to do is to lift the salient points out of the document. So I'm going to give an opportunity to the DM to make an opening, and then I will give an opportunity to the Road Accident Fund. Let's say 15 minutes at most, so I'm going to be generous. We normally give 5. So I'm going to be generous and say 15 minutes, again recognizing that the members have gone through the presentation, but you might want to provide context to some of the things that you've put in the document. So please lift them. Because this is being streamed publicly, there are certain issues that we must just manage carefully in order to manage time. And one of those is the litigation between the Auditor General and the Road Accident Fund. Somebody's phone is chachara. So the matter regarding accounting standards and the audit outcomes and so on, you certainly may refer to it. It is not my intention to go over the same ground again here, because we had the discussion before. The matter is in court. The courts will soon make a decision. And once the courts have decided, all of us have to go with the decision of the court. That's just how our constitution works. So I don't think trying to do the job of the courts in this committee is going to be helpful to anyone. Safe to say that we need to record that that is the basis of the finding by the Auditor General, and that the Road Accident Fund disagrees. I also want to make a couple of comments sort of on a wider issue. You know, it is budget time, and it's got the effect of sharpening the mind. So one of the things the finance minister announced is that there will be no increase to the rough levy. Now, you know, motorists are happy when they hear that, but I don't think the guys at the Road Accident Fund were happy. As motorists, you may have been happy, but as management of the Road Accident Fund, obviously it means less money in your budget. We fully recognize that issue, and I want to say that I kind of felt your pain in that respect, because budgets are give and take, particularly in the context of the funding problem we have discussed before, that we need to find a way in which the Road Accident Fund is able to balance the books. We're able to manage the policy issues around the Road Accident Fund and the claims processes and applicable legislation and so on. So I'm just trying to say, you're not coming to a committee that is intransigent to some of the realities that the Department of Transport and the Road Accident Fund is having to work through. What is important is that we work together. We work very closely together to make sure we get to outcomes that best serve the South African people in the best way possible. So the way we're going to do the proceedings this morning is that the Honorable DM, Deputy Minister, will open, and then we'll give an opportunity to, and please, introductions before we start. I always forget this because we've met each other before, but the public not. That we then give an opportunity to the Road Accident Fund team to lift the salient points out of the document they've submitted to Parliament. Also gives the public an opportunity to see what is in the document, because the event is being streamed. And then we will go to questions. And the way we do it is that we allocate members, so sufficient time to have an interactive conversation. So we don't like just do the rounds and everybody asks 5 questions and then it takes another hour to answer the questions, and then members are not happy because not all the questions were answered. So we will give, because we divide our work as members amongst ourselves, so we'll give 2 members an opportunity to have a back and forth with you colleagues, and then once that is done, the rest of the members also ask any questions that have not been dealt with as we deal with all the themes raised by the Auditor General and the Special Investigating Unit. I really would like us to finish before 1 o'clock, or at least by 1 o'clock. So it is not our intention to keep anyone here longer than we should. The Deputy Minister has alerted me to the fact that there is an important meeting he's got to be at, but only at 12, not now. So he's going to be with us for the next 3 hours. And so we'll also try and manage our program in such a way that any questions, especially closer to that time when he's got to leave, any questions the members that may have for the Deputy Minister, to make sure that we direct those questions to him so that he may then leave and attend to that business. So that said, welcome once again, Honorable Deputy Minister. I'll hand over to you, and then to the RAF team, and then RAF team, not RAF, RO. and then over to you, sir.
No, thank you very much, Chairperson. Colleagues, good morning. It's always good to be at Scopa. It's a nice case of deja vu. Given that my formative years in this parliament for 10 years was spent here. So it's like a homecoming, so be nice, please. Chair, thank you very much.
We cannot guarantee.
But no, Chair, thank you very much. And on behalf of the Ministry and the entity REF, we appreciate the opportunity to appear this morning to report on REF-related matters and on issues that had been previously been the subject of our discussion at our last meeting. My name is Mkhuleko Hlengwa, the DM of Transport, and I'll request that the chairperson of the board, who's to my immediate left, introduces herself and the board members who are here, and the CEO and the executives. And then I'll just make 1 or 2 comments, Chair, and then we will be in the hands of REF, who have got a presentation. Chair, I had asked that there's some changes to the presentation, but they're not fundamentally substantive. So I think that whatever changes there will not materially change what the honourable members would have received when the presentation was submitted, but I think the team will point to that if it's necessary. Thank you, Chair. Madam Chairperson.
Thank you, Honourable DM. Good morning, Honourable Chair of SCOPA, Mr. Zibi, and all the honourable members of the committee, our Honourable Deputy Minister of Transport, and all the team that are here. And I will observe protocol for all those that I haven't greeted. I'm Zanele Lorraine Francois, the chairperson of the board. On my left is Dr. Maboya, who is the deputy chairperson. And next to her is Mr. Nyama, who is the chair of the audit committee. And then we have the CEO, Mr. Collins Letswalo, and his executive team. We have the CFO, Bernice Botchider, and we've got the Chief Strategy and Transformation Officer, Patu Lukwareni, and we have Chief Governance Officer, Ms. Mampe Kumalo, and we also have the Acting Corporate Support Executive, Mpo Manyashe, and on my extreme right, we have the Board Secretary, Muketi Penani. I hope I didn't leave anybody else. So, is it here? And Mr. Radikwena Pora, the Chief Internal Auditor. That's the delegation we have today. Thank you.
Okay, Ms. Potgieter is at the back, right? I just want to be certain. So you're sitting over there, and then the last person you introduced, where are they? Oh, okay. No, that's fine. Thank you.
Chair, thank you very much. I want to start off where you ended and indicate that obviously the budgetary constraints which have beset the country and the fiscus have, amongst others, led to is issues around REF is not a money-making scheme. And so I thought then in that regard, I should give an update on the matters that you had raised with ourselves, and we welcome the opportunity to appear before the committee this morning. And I would now like to hand over to the chair of the board and the executives to do as you have directed around lifting the salient points of the presentation. And then, Chair, to say on cell phones, maybe you need to start charging a levy every time it rings, and we can give
and we can give it to the RAF.
Yes.
We will give that to RAF. No, I agree. Before you step down, Honorable DM, I try and give the public as much insight as possible. Can you help with, at least with a particular matter, and that is two matters. One is just what are you trying to achieve with withdrawing the RAF amendment bill and replacing it with a different amendment? That would be important, just in very simple terms. What problem are you solving? That would be helpful. And then the second thing, just to give the committee a sense of what is the matter between the RAF and SARS. If you can resolve those two, then you can step down.
Chair, it may be my request, because the matter is at its infancy stage, that if we do not substantively exhaust it, we may leave lingering questions. Suffice it to say that the Road Accident Benefit Scheme is a bill that has served before Parliament before, and served at the in the House as well. It went through the legislative processes in their entirety. What we do need to achieve, Chairperson, is to, one, ensure the long-term sustainability and viability of the Road Accident Fund and keep it as a going concern. It needs to be assisted to generate revenue and be able to explore other options for itself insofar as revenue is concerned. Thirdly, Chair, it's very clear that RAF in its current form is not sustainable. If you look at, amongst others, that you have to do lump sum payments to claimants, that is not viable. And the problem that arises is that we pay you today and then you come back in 5 years' time and you're raising other issues. So we need to look at how we pay out, Chair. And then, of course, this will change and alter, amongst others, the regime of the benefits. So they have to be prescribed benefits. And the option we're looking at is not to legislate the benefit in a monetary term, but to give the option for a review on the basis of economic dynamics, inflation, and so on there as well. And then, of course, Chair, we've got an NHI, which has been passed into law. That has got a material consequence to our healthcare management in the country, and we need to look at how we can leverage that for the RAF. So legislation has to respond to the prevailing realities on the ground. So what we'll do, Chairperson, once REF has, one, we will meet with the Road Accident Fund on this matter. Two, they will make their substantive input insofar as the proposed bill is concerned, so that we are then on the same page with REF. But what is important, Chairperson, is the issue of legality as well. To whom do you pay and how do you pay? And the ensuring that the payouts go to the claimants. And I think, as I've said, the issue around lawyers is of fundamental concern to us as well, in the sense that as part of the ecosystem, how do we plug in transparency, responsibility, oversight and accountability to maintain the highest ethical and professional standards from the sector? Because, as I say, REF is not a money-making scheme, either for the claimants or the lawyers or for ourselves for that matter. But Chair, maybe since you raise this and you draw to the public, a fundamental tenet to the long-term viability of the Road Accident Fund remains road safety. For so long as we have got heightened accidents to the extent to which we do, in the festive season over 42 days, we had 1,234 accidents, resulting in 1,502 deaths. Therefore, the targets of the United Nations Vision 2030, that we need to have road fatalities by 50%, and other related matters of the road ecosystem, the road to rail, and ensuring that our, so it's a broader economic question. So for so long as the roads are congested, drinking and driving, drinking and walking, and other misbehavior that you witness on the road, you add a burden further to the Road Accident Fund. So we need to look at this matter in that broad sense. Chair, I'm going to ask that the CEO briefly take you through the matters around SARS and REF. However, as far as I understand it, is that the SARS intends on billing, or rather has billed the Road Accident Fund some 5.2 billion rands for a rebate of a user insofar as their processes are concerned. And so now REF must pay out, I think in tranches of 5.1 billion rands to SARS for them to then transmit to that user. The matter, as I said, is in court because the mediation did not yield the necessary results, and the Road Accident Fund has secured a interim court order. We anticipate, I'm advised, a final court order on the matter by the end of this month. So for now, there is an interdict on SARS collecting that money, or the first tranche of that money from the Road Accident Fund. I don't know if CEO, they would substantively you'd want to take further.
Sorry, Chair.
Sorry?
There's just a technical issue. I've just been informed that the public actually can't see or hear us. So the streaming isn't working. I don't know if you can take it up, please. Thank you.
So can I ask the colleagues just, thank you so much, I appreciate it. So CEO, so let me just ask this. So I'll extrapolate to make your life easier so that you can get to your presentation. The SA Revenue Services, don't want to mention any other names, the SA Revenue Services has in the normal course over time transferred what is due to you in terms of the rough levy that is applied on the fuel purchased. Then involving another entity, that entity claimed and has been granted a significant rebate. And now the SA Revenue Services is saying to the Road Accident Fund, listen, we should have given these guys a rebate earlier on. We've given you the money, so please give it back. And the RAF is saying, no, you gave us money, it was due to us, and we shouldn't have to pay it back. Am I correct? That's how I'm reading what the Deputy Minister is saying. But if I'm wrong, please correct me.
Yeah, thanks very much. Good morning, Chair. I think you are trying to run away from the word ESCOM, but you can actually mention it. The reality is totally different from that. I think it's more about how we administrate what is called the Custom and Excise Duties Act. It starts from Section 75, 1B.
So, no, Mr. Lutsolo, I'm doing this for the public. So
Yes,
can you just simplify?
I'm trying to simplify it, Chair. The difficulty is going to be because you see, people are going to hear the word ESCOM, they won't understand. They won't understand even the part that these guys are now saying they are taking this money and how they took it. I'm trying to explain. So ordinarily, there is a thing called a certificate. So once they collect the money, every 2 months, they must give us an audited certificate, meaning an independent auditor must have looked at this and said, yes, we agree, this is how much the rebate should have been. And this has not happened over the last probably 7 years where this was audited. So we then, in November, get told that there is 5.1 billion due to an entity. And this 5.1 billion is going to be deducted from our monthly amount. And they said we'll take it 2.5 and 2.6 billion in January and February. Of course, Chair, the question was then for how long? They say they've had this dispute with this taxpayer since 2019, between 2019 and 2021. The question was, so for how long were you sitting with this and not telling us? And that's the beginning of it. But what we then realized is that they entered into a settlement agreement. Certainly, they refused ESCOM this rebate since 2019. And suddenly they entered into a settlement agreement to pay it. And our argument is simple, is that the CEA is very clear about what they must do and monies that they are due, and we are saying this is not due to ESCOM in our view, and therefore they can deduct that money. So that's the difference between us and SARS. And we did get an interdict, interdicting them from deducting these monies until such time the outcome comes.
Okay, so please help me again. I hope the streaming is better. So I do this with everyone, so I'm not doing this for you. So in essence, and I'm doing this so that people follow. So when we pay for diesel or petrol at the pump, part of the liter the charge per liter goes to the road accident fund. The other operators who are entitled to a rebate make a claim against the SA Revenue Services, which may agree or disagree with them. In this case, they have been, the reason I was being conscious, because tax matters also stay confidential, so we can talk about you, but I was cognizant. So, so this entity has been in a dispute with the SA Revenue Services about this rebate. And it's clear that the rebate is so large that having reached a settlement, they're now going to the road accident fund and saying it's having an impact on the total amount of money that we allocate to you. And therefore, going forward, we're going to give you 2.5 billion rand thereabout less than we normally do, so that we can then pay this other claimant with whom we have reached a settlement. That's what they're doing. And you are saying, no, you're not applying the legislation correctly. But where I'm trying to get to is, are you saying they should not deduct the money, or they should do something different? That's what I was trying to get to. So I want to know the remedy so the public is following.
We are saying, Chair, as they had said before, ESCOM is not so entitled, so they can deduct that money. That's what we are saying. So it's 5.1 billion made out of 2.5 and 2.6 billion that they wanted to draw it in tranches. And we are saying no, it cannot be, because that must be done in terms of the CEA, which is Custom and Excise Duties Act, and that was not done. That's what we are saying.
Okay, just so I understand, you are not saying you shouldn't have to pay. You are saying, so you're setting aside Transnet's, SARS's decision, because materially this matters. You are not saying you should not be made to pay. You are saying your process at arriving at this settlement did not follow legislation. So in effect, you are stepping into the breach to set aside a decision between the SA Revenue Services and the taxpayer. Put differently, had they followed the legislation in your view, you would not have a problem with the deduction. Because that's a very big and material difference. I need to understand.
Yeah, absolutely, Chair. This thing is done in terms of the law. We are saying people must follow the law. The law says you must audit the certificates that were never audited. The law says there are certain things that must be followed. Even entering into a settlement agreement is actually done in terms of Section 77I of that Act, and we are saying that was not done. So all we are saying is that we disagree with the part. They are not so entitled, and therefore that money still belongs to us. That's what we are saying, Chair.
Okay, we'll deal with this later. We'll deal with this later. But I just want to place on record there is a very important material difference between saying SARS is not doing its job in respect of a taxpayer with whom you have nothing to do with, save for the fact that it affects your revenue, and saying that you shouldn't get the money, because that's where I was trying to get to. I don't want to prevent you from following your presentation. Maybe we do this at another time. But for my own understanding, you're applying to set aside a decision in respect of another taxpayer, in effect, because you're saying they didn't, in arriving at that decision, they did not apply the legislation, because there are two sides. There is the SARS's decision in respect of taxpayer A. Two, there is SARS's decision not to give you the money as a consequence of the settlement. Which side of this are you playing?
Chair, it might be both, but let me explain it this way. All we are saying is we are not part of that settlement agreement. That settlement agreement is not part of CEA, and therefore no money must be deducted on that way. They can agree with the taxpayer. That's not our business. That's theirs. All we are saying is that it can only be deducted from our fuel levy if it went according to the CEA, and it didn't, and therefore they can't withdraw. They can't do that. They can continue with a settlement agreement. We are not included. We are not a party to that settlement agreement. All we are saying is that once it's not done in terms of the law, they can't withdraw that money from us. So that money still belongs to us. Thanks.
Okay, thanks. The DM, you said the matter by the end of the month will have been decided. Okay.
No, Chair, I had tried to summarize the summary deliberately, that there's an interim court order interdicting the deduction or the collection of this money, and a judgment will come out at the end of the month. It may provide clarity so that we do not try and adjudicate the matter here, because I would imagine that there's a layer of complexities at play, and obligations and duties and responsibilities in the moving parts of this ecosystem. As I've said, a mediation process was suggested, and two esteemed judges were part of that process. It did not yield results, and the matter is now in court. What we will do, Chair, is once the matter reaches its logical legal conclusion, then update the committee, even through writing, what is the outcome and where does that place things before us. I myself, I'm awaiting that court outcome, having been briefed by REF that there's this matter and the action steps that they are following are as I've outlined, and would beg your indulgence, Chair, that we come back to you on that matter. But I thought I should bring it to your attention that there's another legal matter that is of substantive import to the lived reality of REF, because it's got a material consequence to its finances if you look at the quantum of money which is at play. So we will come back to you, Chair, on that one in earnest. Thank you.
No, thank you. And it's more than 10% of what they're supposed to get per year. So it's a significant amount of money. No, I recognize that. Thank you. So can I indulge you then with about 10, 15 minutes to lift the salient points, and then we'll get into the conversation. Thank you.
Thank you, Chair. Chair, let me just take this opportunity to acknowledge 2 points from the Deputy Minister's points. First of all, the lack of increase in the RAF fuel levy for 5 years in a row. It does have a significant impact on our funding, given that this organization is underfunded already. And secondly, we also note with surprise and concern as a board the withdrawal of the Road Accident Fund Amendment Bill, because the strategic turnaround and sustainability of the fund was at the back of the REF Amendment Bill eventually being enacted into law. Nonetheless, the board will then have to go back to the drawing board and start reviewing the strategic outlook of this organization, because this is a fundamental shift in the mandate of the RAF. So we're going to need time to realign our strategy, our plan, even the structure, and obviously the funding model. And we are also looking forward to the engagement with National Treasury to obviously find other possible viable ways of funding the RAF going forward. And then on the current presentation, I will allow the CEO to take us through because I think some of the matters you've already alluded to it. I'll hand over to the CEO. Thank you.
No, thanks very much, Chair. Thanks to the Chair of the committee and the members. I'm going to try, Chair, to look at this, because you are saying it has been read and it's going to be difficult to go through it much more in detail. So I'll try to touch on the most salient points that you would have, and you would have to guide me as to whether at the pace, because
In fact, what you have an opportunity to do as the members ask questions.
Yes.
If a matter appears on one of the slides, you still control the thing. You can then go to that slide and explain. Yeah. So don't worry. We'll give you other opportunities as we interact.
Yeah. No, Chair, I think the RAF has gone through a lot, and I think developments are there that suggested that at least in the last 5 years, all the targets that we have set ourselves, say for the legislative ones, have been achieved. You'd remember, Chair, that when we started, the issue was about the sustainability of the RAF. So everything that you'd see here takes shape in that form. I must emphasize, Chair, that without legislative changes, we must talk about the existence of the RAF and whether it will continue to exist post that, because I think efficiencies can only buy you a certain amount of time until you then really start to cut into the actual flesh of the organization. And really, I don't think that RAF will survive going forward without increases in the fuel levy or the change in the structure of its asset and liability makeup. So let's talk about the claims backlog, Chair. I think one of the most difficult parts of this legislation that we are implementing is the Section 24 of the RAF Act, its claims procedures, Chair, they are in the legislation. We have never seen something like that. I've been in government for a while. There is no claims procedure. Procedures are usually in the regulations, but this one, they are there in the act. Meaning for us to change procedure, like the way you submit a claim, it is specified in legislation. You must bring a form to us, which form must be filled and must be submitted to us either physically at our offices or through the post office. Now, I don't want to bash our colleagues at the post office, but much more of those things we never receive. But the problem is 24/5, which says that if we don't receive, if we do not do anything to that claim within 60 days of receiving it or it being posted, then it's valid in all aspects in law. So we sit here with a backlog because of that. So we look at this thing, and 93% of all these claims were in a backlog. And when we looked at this backlog, 93% of all of them did not have all the minimum requirements. And most of them had passed 60 days, meaning they were valid in all respects in law. So that's the difficulty. So what are you finding in here? Someone who have just filled a form, incomplete as it would be, the fact that it has been registered and that it has been sent to us, it's a claim in all respects in law. So that's the difficulty. So we then set up a target, a very ambitious target. And we said to ourselves that no, in the next 5 years, we want to do away with this backlog of 3 years and above. And then we divided that into 5 years of the strategy, and we put the 20-year target, 20% target, multiplied by 5, it will give you the 100%. So we thought we'll do away with this backlog. We then went into the backlog, Chair. We find out that we can't find these people that firstly applied. It was worse because it was not even better when it became to what was called direct claims, which means people just came to us directly without using a lawyer. It was very difficult to find these people. But there was also a perverse incentive that was given at the time. In hindsight, you look at it, you think, oh, that's what we wanted to do, but the difficulty with it was that we then created a perverse incentive of our own people bringing claims and registering claims directly, which claims did not have all the requirements. So you would have thought it was lawyers that would have brought this, and they did not meet the requirements. But the ones we received ourselves in the direct claims book were also did not have all the requirements that we sought to actually make an offer so that we can close that claim. So that inefficient allotment process led to, it was just a minefield that we had to navigate. So we have been missing this target by about 3-4% each and every year, meaning around 16.9% in the previous year, which we have not achieved by about 3.1%. This, as a result, you would see that we have now put the minimum requirements as it were. So we have missed that backlog as a result of that. What have we done? We have gone out there and called South Africans to say, come and settle your claim. So we ran media campaigns. We have done what is called block settlements to try and settle that. Every time we do this block settlement, people come up with claims that are not part of the 3 years and older for some reason. And of course, you would have seen, Chair, in the media where one of the legal law firms is fighting us for contacting their own clients, asking them to come and settle their claims because they are called through the call center. And our response thereof. So we try to push to make sure that the people come and finalize these claims because they are valid in all respects in law. We are getting a legal opinion of whether we could actually move and remove some of these claims from the backlog, simply because we have done everything in our powers to try and get these people, and it would seem like we can't get them. The disadvantage, Chair, is the people that are out, the majority of our people that are not as educated. These things are with their lawyers. They don't know what to do. So that's going to be the disadvantage. That's what we are trying to run away from in trying to phone each and every one of them, even if they are represented by lawyers, because we realize that lawyers are more interested in going to court than actually settling some of these matters. Now, then we come to the second part, Chair, and I think we must share, Chair, a document. I think it comes out of the Advocate magazine, and we must share the 365-page Musenege committee on the judiciary and its thing that was issued last year. Because, Chair, when you read that report, you can't find RAF anywhere in that report. And it would seem like we are scapegoated for what happens in the judiciary. And we just think it's a tad unfair. And then you read the 2022-23 annual report of the Department of Justice, and you will see that this issue of backlog at the courts is an issue. And RAF does not appear anywhere there. But it would seem when people, every time they talk, anecdotally, it's RAF that is a problem. Chair, we are a litigant. And half the time, actually 90%, if not 95% of the time, we are respondents or defendant in the matter. We don't start this battle. So people take matters to court, we defend them. But when you defend a matter, it doesn't get off the court roll. Unfortunately, it remains there. So you need to then deal with it. But it is time we must, as South Africans, look at this thing and ask ourselves if from 2009, according to the Musenege report, to date, there has not been an increase in the staff establishment of judges, when exponentially the number of matters has grown. Whose problem is it? Because you see, it's easy to come and sit when there are no judges. By the way, there are no judges. And if you go to the judiciary, in the Musenege report, it's very clear. You are going to find that the number of judges have not grown since 2009. So for 16 years, nothing has moved. But I think why we want to share this Advocate magazine's article with the committee is because it shows that at some point people were worried about what they call the death of RAF matters on the court roll. They say the courts have become a veritable ghost town because RAF matters are no longer coming. And you'll see in there they mention the efforts we are making to make sure that we settle these matters. And you'll see it with the increase in the number of matters that we have settled. It has increased from, I think, 57% to about 81.9%, showing you that all those matters that, if we did not settle them, would have landed in court. So we are trying to assist that. But also we participated in a mediation pilot before on our own. But now we are working with the judiciary on another pilot of trying to take all these matters off and trying to settle them using mediators. We have agreed to that because we believe very strongly that our aim has always been to settle and reduce legal costs. Because the problem, Chair, is the legislation. There's no way in the world where you're going to find a social benefit scheme that is based on the fact of someone suing the state to get their benefits. And that's what happens. If you say to someone, bring a form, And if we don't respond to you, issue summons, you are saying sue me. And that's all you are saying. It's based on delict. It's a problem. We are raising it as it were. And I think that we must look at. And I don't want to go, Chair, into the nitty-gritties of ratios of matters in the court, because I'm just saying we must not be scapegoated for what happens in the court as a matter of fact, as if, I mean, you look at the Moseneke report, we will give it to you, you read the recommendations. It doesn't talk about RAF, but we believed very strongly that if we had the Amendment Act, most of these matters would have been removed and would resolve it. It's our view. But of course, you must know, Chair, that anything that is going to unplug attorneys out of the system, we are going to court, Chair. They are going to fight, and they've been fighting us for the last 5 years. They are going to fight even more. Whether it's RAPS, whether it's the amendment bill, anything that removes lawyers out of the space is going to create a situation that way. So there are proposals about let me jump off to the AGSA proposal about payments, Chair, which we never necessarily agreed with, but we said that's fine. Nothing turns on it, Chair, because when we started, 29 billion of the 42 billion was going to claimants. We are sitting here, 45 billion of the 48 billion is going, claims expenditure has increased, that's substantial. So it was sitting at 29 billion at the time. We have increased it. How did we do it? We took out the efficiencies, as we say, we reduced the number that was be paid to medical experts and the amount of money that was paid to lawyers. We have saved about 12 billion over the period on medical costs. We have saved about 24 billion over the period on legal costs, and all that money went to the claimant. We pride ourselves with that, Chair, because that's what the RAF is meant for. It's meant for claimants, as it were. And
so you said I should guide you with time,
yes.
so you've got 5 minutes left.
Okay, thank you. Then we deal, Chair, with the claims paid versus the cash holdings that we have. And you would see, Chair, how we start this thing. Towards the end of the year, which is now, we will flush all the cash that we have for obvious reasons that at that point is towards the end of the year. And we want to carry a certain amount of cash in our books for obvious reasons that we have got attachments, we've got all those things that we must do. And part of, you would see tipping down in Q3, but at the beginning of Q3 or in the middle of Q3, we were told of this 5.1 billion from SARS, and our view was that let's try and slow down on the payments just in case we are going to be having cash problems. The worst thing, Chair, we have never in this management or during the period where we have been in charge of this RAF went to the National Treasury for a bailout or intended to go there, notwithstanding the fact that the fuel levy has not increased. And all we're saying is that let's cut to fit. And maybe we are victims of our own success. Once you do that continuously, people just believe, no, don't worry about those things. They will see how to take care of themselves. Because if you look at, even during the time when RAPS intended was said, there must have been a situation where there is a bailout of some sort. So the RAPS bill on its own at the time relied on a bailout. We looked at it and we realized that given the fiscal outlook, there's no way in which we'll get money from National Treasury. But it didn't make sense that we are paying a lot of money to lawyers and then we go and ask for a bailout. We said, no, let's start with these ones. let's reduce that. But how we're going to reduce that is just to make sure that we settle rather than litigate and reduce the litigation costs. As you will see total spend on litigation over a period, you'll see, Chair, that is not even in line with what we used to spend 10.6 billion every year on legal costs. And I think now we are sitting at around 3 billion a year. And as we say, we have saved about 24 billion over 4 years, as it were. Now, the top 10 attorneys legal costs, Chair. This is quite an issue that we had also to deal with when we arrived, which is reducing legal costs and what we pay to these attorneys. Because if you look at it, Chair, the most painful part is where someone calculates your loss of earnings and says, in the whole life as you are, Collins, you will be paid 6 million. So we are going to give that 6 million to you now. And then I go to my lawyer and they say, because you're a lawyer, a quarter of that must come to me. Just for helping me get what I'm entitled to, because for us that becomes...
Sorry, Mr. Lutolo, I just want to understand this slide correctly.
Yeah.
Are these legal costs or are these claimant payouts through attorneys?
These are legal and other costs, if I understand it very well. I'm sure that this does not include the part that is paid to the...
No, sure. So I just want to understand. So basically, if you take the Brolio attorneys over there, if we were to then include the amount of money that is meant for claimants, that number would be higher. Would that correct?
It will be probably 1.3 billion.
Okay, so what is generally the proportion of what attorneys claim versus what eventually, and this is just on an average basis. Do you guys know?
Yeah, well, party costs, Chair, become lower. So these are party costs. So meaning between what they claim as monies that they've spent in legal costs on the execution. But you must know that, remember, this thing is based on contingency fee agreement that allows them to take 25%. So this is excluded outside the 25% that they would have taken. So DiBrolio takes about 1.2 billion every year paid out of ours. So take a quarter of that and see how much DiBrolio makes. This money, by the way, is party cost that you expect them to pay to the claimant. It never goes. So
just explain party cost.
So party costs are costs of litigation. So the cost of litigation, so they will go, let's say you are given 10 million. The 10 million is what you'll get in, let's just say, the whole claim. You are given 10 million. 2.5% they will, 25% they take, a quarter they take for themselves. Now they come back because the law says the RAF must pay for party costs. They then claim this party costs. Because they've already taken their 25%, this party cost must actually go to the claimant. They never go. I can assure you that majority of this money never found its way into the hands of the claimant in any way. They never even tell them you're entitled to that.
Okay. No, thank you. I'll give you a chance to wrap up because we're out of time.
All right. So,
Sorry, Chair.
I'm not going to go...
Sorry, Chair, can I just ask a question about, because I think it's quite contentious, that issue of the 25% going to lawyers. Is it allowed in law?
So you're one of our lead members, so can you deal with it in your question time? So just note it. Please wrap up, Mr. Litso.
Yeah. So there's issues, Chair, about fraud detection that I don't want to go into. I mean, we detect a lot of fraud in the system. And I think the other issue was the vetting, there's the status. And of course, on the filling of vacant posts, there's the issues. I'll take any other issues. We'll take, as we take questions, we'll go back to this if it's in line with the presentation. Thank you so much.
Thank you very much, Mr. Litswalo. Okay, so we are going to give an opportunity to the members, and I see Honorable Skosana has been training there is fit is ready. So I'm going to begin the stopwatch now. So you get an opportunity to interact with the Road Accident Fund team. And then after that, it will be Honorable Atkinson and then Honorable Madlala after the break. Thank you. Please go ahead, Honorable Skosan.
Yeah, no, thank you very much, Chair. And good morning to yourself and honorable members, the Deputy Minister, the leadership of the RAF, and all other stakeholders present and our support team. No, we really appreciate this opportunity to have an engagement with the RAF. See, I'm getting used to this thing of calling you RAF because where I come from, we call you RAF. So since I've been in this committee, I'm learning that it's RAF. Yeah. No, I will ask all my questions at once, and then you will respond, and then I will come back if I have a follow-up question. In the 2023-24, you maintain the adverse audit opinion that you got in 2022-2023. And then the main cause, obviously, like you have also indicated, is the use of accounting standard, which is IPSAS 24. No, we're aware, as we also reiterated, I think earlier the DM, about the issue of continuous litigation processes in this regard. So my question is simple, is that, are you prepared to continue getting an adverse or a disclaimer audit opinion for as long as you are pursuing this matter legally, no matter how long it takes? Now, my second question, in 2023-24, you reported a deficit of 1.5 billion rand. And so far, your total accumulated deficit, it's standing at 25.5 billion rand. And your total liabilities are exceeding your total assets, which means you have a solvency challenge that may affect your ability to fulfill your mandate. And I've heard the CEO, I think, talking about the issue of increasing the fuel levy and or changing the legislation that relates to the funding model. Is that the main cause of accumulating this deficit? Is the issue of the full levy and or changing of the legislation the main cause that impact on the continuous accumulation of this deficit? My third question, according to HGSA, there's a lack of oversight regarding financial reporting and compliance and related internal controls. And further than that, there's ineffective preventative controls in place to ensure compliance with laws and regulations. What is your comment on that? My fourth question, Chair, the performance of RFA against their annual targets for 2023-2024 is standing at 85%, which is good, although it's slightly below the previous years. The previous year of 2022-23, which was at 91%. As much as 85% is good, but why did you decline from the 91% to 85%? And with regards to your target, you set a 20% target to deal with the 3-year-old open claim, which is the backlog. So my question is, why did you set such a low target? Because say a person has an outstanding claim, which is 3 years now, and then now we are setting a 20% target. If we were doing that for the next 5 years, it means it will take you 5 years to totally eradicate the backlog. It means a person who's already having a 3-year backlog, his or her claim has not been attended in the past 3 years. That person might have to wait for another 5 years. It means that claim might be attended after 8 years. So why are you setting such a low target to deal with the 3-year-old backlog? And what is it that we are going to do to address the documentation issue to meet the future targets? Because I think you did mention that the reason that we did not achieve the very same low 20%, I think we are at 16 point something percent. The reason you mentioned the issues of documentation and stuff like that. What is it that we are going to do to address that? Now, with regards to the issue of irregular expenditure, what disciplinary actions have you taken against officials responsible for irregular expenditure? And when will all outstanding determination processes be concluded to ensure effective consequence management? My last question, Chair, is with regards to the vacant executive management positions, which in your report, it says that recruitment process is underway. How long have these positions been vacant? And to what extent have these vacant posts negatively impacted on your operations and claims processing efficiency? Thanks, Chair.
No, thanks, Chair. Thanks, Honorable Skosana. Let me preface this by saying, look, no one can ever find joy in getting a disclaimer, adverse opinion. Certainly some of us who are finance professionals find it very difficult to deal with matters of adverse and disclaimer. But also, it is our professional duty to account accurately in our view and use our professional judgment. And this is what has happened in this regard. We never thought it would take this long. Are we prepared to change? We might have a professional way in which we look at it, but we believe very strongly that the decision we took is the right decision. And therefore, if that results in an adverse or disclaimer in the view of the AG, which is what we are disagreeing with, then we have to take it to that level. Because if we don't accept this, then it means we don't table financials in front of Parliament, which is the worst thing that can ever happen, that accountability is not taken. So, yes, for as long as we know what it means. Certainly from a management perspective, and I think the chair will then deal with the matter from a board perspective. I think there might be nuances there that may be different. The issue around the accumulated deficit, I'm gonna put it this way. If your revenue continues to be reduced in real terms, so we get 218 cents 5 years ago and 218 cents today. in real terms, our revenue has been reduced. Because if you take inflation into cognizance, especially medical inflation, then it becomes even worse. Because it's double digits, we are paying costs as it were. And you'd know there's been increases in different things, and that you will always find yourself on the other side if your revenue is cut. Yes, the deficit will come. But we must match this with the idea that accidents continue to happen and people continue to need to be paid. So the side of our liabilities will always increase, and this solvency challenge will always be there. Mr. Skosana started in 1981. I was 4. So you must know that the RAF system has never been sustainable. It started in 1942. In 1946, this thing was, it started in 42, ran from 46. In 48, it was bankrupt already. We sit with a lot of commissions of inquiry into why this thing is not sustainable. It's simple. There is no social benefit scheme in the world that pays people in lump sums. What are you trying to achieve? What is the big win that we can have? Forget RAPs, forget anything else. If tomorrow you say, pay these people in annuity, as you are receiving your money in your annuity, you are buying us 20 years of sustainability. That's the reality. Because you give these people this lump sum today, in any event, in a year's time, it's gone, they've blown it. So, this lack of oversight and financial compliance is in reference to the very same number one issues, because there, I mean, you can ask the AG. I don't think that it's about any other matter, save for the matter of the accounting treatment, which continues to be an issue. So far as any other issue is concerned, we are quite clear that we are running a tight ship in that regard. Performance 85, 93, 21.3 to 85. Yeah, it's one of the issues we are supposed to deal with, which is the what we call Project Bukamuso, which is the integrated claims management system. We missed the target because at that point we couldn't push. There were a couple of issues that we had to finalize. One of them was that it was going to come in that year and it had to be postponed to the next year, so we missed that target. So that is the main issue there of that. So don't I think that 20% is a low target? Absolutely not. Our predecessors had a target of settling matters in 1,440 days. It was in their annual performance, or actually their strategy. They strategized. So if they spent 1,200 days in finalizing a claim, that was an achievement. We have put a target of settling matters in 120 days. So you can imagine, we are doing that. We are also dealing with the backlog that was already there. In there sits, and this is what we have said, even in terms of what people were fighting about, we deal with the oldest claims first. So you would find that the claim has been sitting there for 5 years, but then we deal with it first. But it's a moving target as well, because 3 years and above of last year, once you finish this year, you add the one of last year, because there will be 3 years. So it's also a moving target. It's not a target that would say, so it's cumulative as it were. We don't think that it's a low target. We think it was quite ambitious, but we kept it because our impact of this strategy has to be meaningful to the claimant. and that's what we do. If you look at it as well, when we do this, we prioritize like children's claimants, children's claims, because we believe that once a child loses support, that child must be supported as quickly as possible. You would know that most of the lawyers would receive this thing in a few months, but they actually wait for 3 years to actually put the claims in, because that's what the law allows, 3 years for them to be able to claim. So it's something that we are saying from a targeting point of view, we think that it's reasonable. Documentation issue, what are you going to do? Well, we are going to battle in court, because our RAF Form 1 has been taken to court. When we say give us more information and all the information, we are taken to court by lawyers. But they'll tell you they're interested in settling matters. We say give us information so we can settle the matter. A very interesting observation that you must make. Anyone who gets paid from RAF or RAF is someone who must be seriously injured. You must watch them on I blew it and tell me if there are serious injuries there. Seriously injured means you must at least be 30% disabled. Majority of the people that claim from RAF are not like that. It suggests that there is something happening in the space, and much more from lawyers, much more from doctors exaggerating the injuries. So if someone is not impacted upon, so you'll find that someone will say, I'll never work a day in my life when they claim from RAF. And then 5 years down the line, or when they get paid, you go and check with SARS, they are paying pay as you earn, meaning that they are earning something. So that's another issue that you'll see. So the targeting of this individual. But also we are paying rich people. There's a social benefit scheme that pays rich people, and it pays them more than the poor people. That's how this system is sitting, and which is what we sought to try and change with the Amendment Act. The irregular expenditure, the outstanding determination process, there is a process that has been issued by the National Treasury that we go through, investigation, everything, and we do that. And you'd see, I mean, we have taken a lot of action, and when those things do happen, irregular expenditure and otherwise. There's also progressive discipline, because you can't just sit. There are irregular expenditure that is a result of people making mistakes. People that don't work will never make a mistake. The ones that work always make a mistake, and we must balance that. We must balance that from people just having a one disregard of rules, and people that will make a mistake. And when they make a mistake, of course, I mean, they sit there with final written warnings and all those things, or written warnings or whatever the case may be, because it must be progressive discipline as well. Vacancies, yeah, they do affect us, especially in the operation side. We went 3 times to the market. RAF is a specialized skill you require in the space, especially in operations. So we've been struggling to fill that position, as it were. We went to the market 3 times, we can't get people. But also people don't want to work for an organization that half the time is about to close. Or it has got all these things in the media and all that. It's very difficult to attract that kind of talent. We have seen that improve over the years, and we think that over time we'll do that. How long has it been? It's about 2 years, because the structure was finalized and we changed the whole structure, and some of them was a result of that structural change. The vacancies were created as a result of that. I hope I've answered all the questions. Maybe I must hand over to the chair on the issue of the adverse opinion and whether we want to keep it and perpetuate it going forward. Thanks.
Thank you, through you, Chair and Honourable Member. The board actually considered this matter extensively. We did a lot of research before we arrived at that decision. And we also looked at the long-term effects of the application of a wrong accounting standard. And in our mind, with that kind of research, it just didn't make sense that the organization will stay with this huge liability, which is not real, based on a calculation behind an accounting standard that is not correct. We just realized that it wouldn't be in the best interest of the organization. And also the fact that it's sitting in court, it will make sense to get an independent adjudicator that will give us an objective view of this. So obviously it will really give a sense in terms of clarity on the policy and on the technical side, but the major decision is around the sustainability of this organization based on the liability, which is not calculated correctly. So that's why we supported the decision of the executive, and will allow the court decision to guide us when it comes. Thank you very much.
All right, thank you, Honorable Councillor. So we've run out of time. Do you have a follow-up on anything? I'll indulge you in that way.
Yeah, well, just one. Chair, on this issue of litigation between RAF and HSA, are there any developments since our last engagement? I don't remember on which date we met with you, because you did brief us like you are doing now. But since that day until today, are there any developments on these litigation processes?
Chair, yes, there's a couple of things that happened. We got correspondence from the executive authority instructing that we must try to find solutions, which included going back to the ASB and going to the Auditor General, which we did, and we have since got responses from them in this regard. And then, of course, from the court point of view, no, nothing has actually moved. We are still waiting for the outcome from the president, as it were. So we are waiting for that. But yes, we went back to the ASB about these matters. We went back to the Auditor General on the matter as well, and we also wrote to National Treasury to try and get that. Maybe I must also allow the chairperson of the audit committee, through your chair, if he can also add anything. Thanks.
Good morning, Honorable Chair, members of the committee, Honorable Deputy Minister, my colleagues, and executives, and everyone in the House. Chair, indeed, we received a letter from the department guiding us what to consider to explore issues of accounting policy. From an audit committee point of view, we indeed wrote to ASB. We also wrote to AG or AGSA. We are in the process of then consolidating that feedback to then formulate a proposal that we will then send it to the board, to then for the board make a determination. As a statutory committee of the RAF, which is the audit committee, we are not happy, and obviously we derive no joy for continuously getting this type of audit outcomes. And we are trying our best to ensure that there can be a technical solution that doesn't give rise to dispute between the auditor and the auditee. Highlight or high-level feedback, I think the feedback that we continue to get, Chair, it's quite grey and it's not helpful in many of the times. What we're trying to seek from an audit committee point of view, it's really on the process and procedural aspect to say that for one to review the accounting policies, what are the steps that need to be followed to get to that conclusion? Second to that, we have asked the question as well to say, what is other audit or accounting standards that are there that should be considered. And we haven't got a clear answer as well. And where we are, obviously, Chair, we don't want to find ourselves changing a standard for the sake of achieving a certain audit outcome. I think we want to take a responsible decision and make sure that we follow process and procedure. Most importantly, we want to ensure and make sure that the reporting of RAF, it is correct. I think it is an expectation and a duty from ourselves to ensure that those happen. We will continue to update this committee. Thank you so much, Chairperson.
All right, thank you very much. Deputy Minister.
Chairperson, thank you very much. I had taken heed of your opening remarks, but I see that the matter is being ventilated, and therefore, for the record, I want to reiterate, we do not support this cause of action of being in court insofar as REF and the AG is concerned. And I think that has been made abundantly clear to the Road Accident Fund in this forum and other forums. It remains our position that this matter should be out of court and that the processes, including but not limited to the engagement with the ASP, must be followed. And the chairperson will remember that at the last meeting we were here, it was reported by REF that the ASP had indicated that they were in the process of developing an applicable accounting standard. And therefore it remains our outlook that that should have been the maintained position. This matter has been in court for a protracted period of time, and at every instance, REF has not received a favorable court outcome. And that remains of fundamental concern to us in the ministry. So I thought because the matter is being ventilated, it would be remiss of me to not put the other position, which is the flip side of the coin, that this matter, as far as we are concerned, should not be in court. Thank you, Chair.
Thank you very much. I'm going to close this matter by sharing this anecdote, and it's really important. The medium-term budget policy statement from October last year has been adopted by this Parliament. Last year's budget, the 2024-2025 budget, has been adopted by Parliament. And this budget being tabled is going to be adopted at some point. At least there appears to be no dispute in respect of the Treasury's view of the Road Accident Fund's financial position. We sit here with a schizophrenic situation, and that's why the matter needs to be resolved. A crazy situation where this same institution, Parliament, and I'm assuming that the annual report of the Road Accident Fund has been approved by the committee. I'm not certain, but in the event that it is, that annual report is at odds with what Parliament has approved in terms of the Treasury's own budget and its view of various institutions. And it's something that we must not take lightly institutionally for a country. And that's why I'm hoping that we get to a resolution as quickly as possible, because Parliament has adopted two diametrically opposed views on the same thing. And I know that MPs and others have lots to look at and care about, but that's in effect what Parliament has done. Anybody who takes one either to court will walk that case to say Parliament has not done its job. So budget has been approved. It gives a number, and you can go and check the medium-term budget policy statement as tabled. The amendments as approved. It gives a number which is consistent with what the Auditor General has said. And when the annual report is approved and the financial statements, they also contradict what Parliament has already adopted. And I don't think this institution should be in that position where such happens. So I am saying to all of you that I hope this matter is resolved, because I know it tends to take up a lot of our time. But what is important is that we follow the direction of the courts. Nobody is immune in South Africa, including this parliament, from the judgments of the court. And I'm hoping that will close the matter at that point. Honorable Atkinson, I'm mindful of time, so what I want to suggest, because we've been here since 9, I want to suggest that we take a 10-minute break, all of us, get some breath, and then we come back here at, what time is it now? Yeah, we come back at 5:02. Can we come back? And I will make sure, I will shout outside. So can we take a body break, and we come back at 5:02, then we'll go to you, Honorable Atkinson. Honorable members and colleagues, thank you very much. So CEO, there is a small problem here at the table. And you said that people who don't work don't make any mistakes. And my colleagues here don't make mistakes. Now I have a dilemma. I want to apply consequence management. I want to apply consequence management, and I don't know what. Now they're busy trying to remember mistakes they've made in the past to escape consequences. But anyway, thank you for that light moment. Mr. Atkinson, Honorable Atkinson, over to you. And I want you to forgive me. I used to work with a man called Peter Atkinson, and I must tell you, on 1 or 2 occasions, I've called him Peter.
Well, this
My
is-
apologies.
At least it's the same initial, so
Yeah.
it's fine, yeah, no problem. Thank you very much, Chair, and thank you very much to the Minister and to everyone from the Road Accident Fund who's come to present us today. A little bit of a follow-on, and I don't want to get set for too long on the legal issue, but I do want to ask the understanding of a question of law. When does the law change? So when are you legally able to follow a particular line that might be before the courts? And my understanding of that, and certainly the Deputy Minister says, you've got to follow the law. So my understanding is the law only changes once the court changes it. So at the moment, the law is basically requires you as a social insurance fund to report as a social insurance fund. You actually aren't allowed to report as anything else because the law hasn't changed. It might be a matter before court. You certainly had a full bench which have turned you down, and you're now relying on the Chief Justice. But the reality is, and he may well change the situation, the law doesn't change until he actually says so, basically, or until he says not, basically. So the question I'm asking here, because the Deputy Minister quite rightly said in the SARS case, you've got to follow the law. Why are you not following the law in this case, in the case with the Auditor General? Why are you not following the correct procedures as laid down in law? And then the second question I want to ask is I want to ask a question of the board. How do you feel in terms of the King principles of actually facilitating what is effectively, I don't want to use the word an illegal course of action, but you're not following the law, basically. And are you not concerned that you could be seen as delinquent directors by enabling a situation where you continually get your disclaimers because you're not following the law? So I want to get an understanding from you as to when you think the law changes. And if you think I'm right by saying it only changes once the court changes it, and you are obligated to follow the law until the court changes it. Okay, I'd just like an answer on that one, and then we can carry on.
So can I, for ease of, so every time a member asks a question, please just proceed with an answer. I don't need to interject between you. I'll only make interventions of time and clarity.
No, thanks, Chair. As it were, in law, there is a thing called audit principle. Audit principle says an administrator's decision or an administrative decision remains in force until reviewed and set aside. A decision of the board or RAF to go through a thing called an accounting policy change in an administrative decision. No one has set that thing and set it aside. No one. So at this point, there is another principle in law called funtus. Once an administrator has taken a decision, they are not allowed to revisit that whole decision unless it's changed by the court. So if I take a decision to appoint someone and I realize I've made a mistake, I go to court and set aside that decision of mine. I don't go and change it on my own unless, then I'll be puntus officio. So there are those principles. But let's then deal with this other issue of legality. So when you go to court and the court below decision is either appealed There is provision 18(1) of the Supreme Court Act that says that that decision is suspended, of the court, is suspended until the appeal is heard and finalized. So all those things are applications of law that we have followed. And I must emphasize that Section 34 of the Constitution is quite clear about who can approach the court. Any person can approach the court to resolve adjudicate over a dispute through application of law, and that's exactly what the RAF has done. So, so far as we are concerned, all those principles given, we believe very strongly that we are on the right side of the law. Thanks.
Okay, it was my understanding that the full bench of the High Court or the Supreme Court basically told you to stick with what the social insurance fund. And I know that you've gone forward to the Chief Justice to ask for that to be overturned. But to my mind, that's the law.
Once you appeal in terms of Rule 18(1) of the Supreme Court Supreme Court rules, a decision taken by the court is suspended. So suspended means it's not in effect. So that which the court has said, once we appeal or put in our leave to appeal, is suspended. We have done that, Chair, I must emphasize. We came to this committee earlier on the Logodi issue, where we were told we are going to pay our, we are hit with the personal cost orders, as both me and the board. And I even said that, I said, well, we have appealed that judgment. We have won that judgment. The SCA has overturned that. But between those things, we didn't pay because it was suspended by the appeal. So once you appeal, 18(1) of the court rule says it's suspended. That's the law.
Okay. Then I'm going to follow on with regards to the documents that you require to have a valid claim. Okay, you have your board minute, and I see that Acting Judge Kolong in the Eastern Cape basically said that you cannot turn down a claim by asking for people's proof of income and various other things. So in other words, they're saying that you've got to stick to the provisions of the Act, and that you can't, that your board minute, which places additional requirements on people, is actually not valid. So my concern there is that you're rejecting a lot. You're actually rejecting a lot of claims that are potentially valid in terms of the law, and potentially valid in terms of the RAF Act, in terms of the requirements of the section. So, yeah, it's Judge Kolong in the Eastern Cape Court in the last few days, I think, has basically said that you cannot demand proof of income from people, and you can't reject a claim on that basis. Okay. So my concern is that we're seeing the financial break. We're seeing your financial statements, but it's based on your board minute, which obviously is an issue because you're asking for documentation that the courts have basically said that that are not required. So how accurate are your outstanding liabilities if you're asking for documentation that's not required, or things that are actually valid claims that you're saying are invalid claims?
Yeah, I think we're gonna have to rely on the Auditor General at all material times, whether we agree with them or we disagree with them.
Yeah.
You are of the opinion that they are right when they are saying that we are using a wrong standard. But it would seem you have difficulties, Honorable Member, in finding, in relying on what they say when they say our liabilities are the way they are. Because we don't disagree on that. So at least let's rely on them consistently. If we rely on them consistently, we differ with them on that, we don't differ with them on that. So they do look at our liabilities and they express an opinion on them. Okay, we disagree on one aspect of the liability, which is the backlog and how we evaluate that from an actuarial basis and all that, and that's the only thing. So the Eastern Cape High Court has got views. Once we realize that, you will find that we appeal those. Because how do we arrive at a point when we are able to determine your loss of earnings if we don't know how much you earn? That's absurdity of the West Order. There can't be someone who can tell us that Collins earns this much, but he must not prove that he earns that much for you to calculate how much he earns. That's quite absurd. And we will of course appeal that if that is the outcome that we have received. You said it's a few days ago. It will probably be making its way to the head office, and of course we'll appeal it, because we don't think that, I mean, we had another one that we are also appealing at the Constitutional Court, at the SCA, that suggested that we must agree to people not giving us copies of IDs, or ID numbers at least, for us to know the hospital serviced Collins. Now they say, no, you don't have to give. I mean, the guy can come and claim a draft and we must just give them, without them identifying who they were servicing. It's absurd, right? So all we are saying is, courts do err at times, and when they make mistakes, that's why there's a higher court that we'll go to, because when we disagree, we'll disagree. But you can imagine the floodgates that says anyone can come and claim that they were earning this much and they don't have to prove it, because we don't want. But also there is a provision of, I think it's section 4 of the Act, powers and functions of the fund. The powers and functions of the fund shall include A, the stipulation of terms and conditions upon which claims for compensation contemplated in 3 shall be administered. I'm sure that must mean that we must put terms and conditions. And those terms and conditions include the documents we would require from someone for us to be able to settle the claim. The aim of RAF is never to sit there and say to people, you are not so entitled to this money. It's not our, but we are given a kitty that belongs to South Africans that we must manage. And we must manage this thing diligently, as if it was our own. You can't just come and give someone money like that and say, no, we are told we must not ask for proof. So where there is judgments that are saying, don't ask for proof, we are going to have to strenuously argue differently. And of course, the only way you can do is appeal those matters.
Okay, and then if the courts don't agree with you?
Well, we'll take it to the Constitutional Court. If the Constitutional Court does not agree with us, we'll let it be. But we'll come to this committee and say, they are saying we must pay people that do not have proof that they are earning, loss of earnings. It's fine. I mean, if they then decide, they've decided. But all we can do is that if it goes to the SCA and we lose, we'll take it to the highest court, because we want that decision. And once that decision is taken, of course it becomes law. Then we'll adhere to it, as it were. Thanks.
Okay. With regards to your investment income, I see there's been quite a significant increase in the amount. I think it's about close on 500 million, around about 498 million, I think it is, which tells me that you have probably somewhere between 8 and 10 billion on call, or invested in some way throughout the year. And I see that you've got a CIO. I was actually just wondering why you have a chief investment officer in the fund, and why you don't just have a treasurer. What kind of investments is the fund making that you need a CIO in the fund? Because to my mind, if you do have a liquidity requirement and you need to have a lot of cash on hand to be able to pay people out, you really shouldn't be doing anything more than having a cash call account or money on call with the bank. So I'd like to know what the reasons are for having a CIO at the fund.
Look, I think we are going to get into
Sorry, Honorable Atkinson, can you switch off your mic so the sound isn't this?
Yeah. We're going to get into a space where generally how we manage is different. So Honorable Atkinson may want to call an investment officer treasurer. It's It's semantics, what you call them. This person must sit there and do an asset and liability management. We choose to call that person a chief investment officer. Honorable Atkinson says this person must be a treasurer. Then another one will say, well, in the structure, that person must fall under the CFO because that's finance, right? And we say, well, we think it's different because our view of liabilities and asset management goes far away from that. It goes beyond that. So it just depends. We have decided to have a CIO for obvious reasons. Our reason was that in our view, we were going to get to a point where we are allowed to pay in installments. That means asset and liability matching means you must go and buy assets and manage those assets for the coming liabilities that you have on your books. And that's our view. So depending on what you want to look at. And you know, there is a view that seems to suggest that at RAF what we sit is look and manage a call account. It goes far beyond that. Because when we started, I must emphasize, our liability book was a dog's breakfast. We had situations where someone was owed 8 years and someone was owed 30 days. And we said, it doesn't make sense, which is why there is a big 180 days thing. So we squeezed that thing. We do what is called liability stratification. And that thing is done by people in capital markets. It goes an intense way of looking at it. You don't naturally get an accountant. You don't naturally get a guy in finance. You get people that have worked in financial markets. And we then had to get people that have got specialties in that to do that work. Lucky enough, some of us have been in financial markets, so we understand how that thing works, and that's how we brought this thing of the chief investment officer into the space. So that's why I'm saying it's a management thing. I didn't want to go deeper into it, but I don't want not to answer you. But it's a management issue and management decisions. And sometimes you might not agree with the way we go about doing it, but it's the way we have done it, and there's nothing wrong with it. Because if there was something wrong, then there would have been a finding of some sort or something like that, which is not the case. But it's a management, it's also a management choices that we at times take. Thanks.
Thanks. Just digging a little bit further to what you were saying, you mentioned the fact that you may look at purchasing assets because of your long-term liabilities. What kind of assets would you be looking at?
Sorry, Honorable Ansin, I just want to ask a question of clarity. Can you switch off your mic? Because and if my recollection is wrong, please let me know. So last time the Road Accident Fund was here, I asked a specific question, which was what kind of investments do you engage in? And I followed that up and I said, is it a call account? And UCO said yes. I said, is that all? And you said yes. And we can consult the record. I then asked you that day whether you have a treasurer or not. You remember that interaction? I asked if you have a treasurer or not. And if my recollection is wrong, please let me know. Your answer was in the affirmative. I then asked you as a follow-up why you needed a chief investment officer if you have a treasurer. Now, I'm quite happy to go and consult the record, and I need to ask this for clarity because we cannot, I referred earlier on to this institution accepting two contradictory reports and adopting both of them, which is a joke. And I don't want us to get into that position again. So I just want you to disabuse me of the belief that you may be telling us something that is different from what you said last time. But I've asked the team to consult the record if they can. I remember I sat here and I was asking questions myself in that regard. So let me ask again. Have you had a treasurer before concurrently with a chief investment officer? At which point did you then decide to forego a treasurer? And are you telling the committee that the Chief Investment Officer effectively performs the duties of the treasurer, and that the only thing here is about naming conventions, but otherwise the committee should have nothing to worry about. The concern I raised at the time was the fact that you said you only have a call account. And by the way, I am not suggesting you're not allowed to take part in investments, but I went with your answer at the time. So can you please clarify me here about that interaction and what you are telling the committee today?
Yeah, Chair. I remember vividly that at that point I said, but Chair, we are getting into the space of management. When you were asking about who's sitting in what position and all that, that's what I said. You can go to the Hansard, I'm sure. At some point, the record will say it. We have never had a treasurer at RAF. We have a chief investment officer who's acting. I don't know where people are getting the word treasurer from, and that's why I'm saying it's nuanced. People, different names, different. This thing is going to always result, Chair, in a situation where we must now go to the.
Mr. Letsolo,
job
you're not answering me.
specification.
I need you to start here. I asked you
Yes.
that day. I asked you that day, what investments do you engage in? And your answer was, it's just a call account. I asked a follow-up question, which was, if it's just a call account, why do you need a chief investment officer? Right? Because there's a certain, names matter. I can't call a CFO a managing director because I choose to do so. These roles matter. A chief investment officer's job is to determine and drive the investment strategy of a firm in order to maximize returns. A treasurer does something fundamentally different, Mr. Letsolo, and that is to do what you were describing just now. Managing assets and liabilities and doing the matching and helping the organization manage its cash flow so that it can meet its ongoing obligations and so on, and to also manage whatever investments the firm may engage in order to serve that purpose. That's what a treasurer does. A chief investment officer's role is limited. I do not think we must get into a discussion here, and it's patronizing to the committee, I must say, where you tell us you can choose what naming convention to give to something that does not apply to it. Please don't do that. This conversation is coming along well, and it's not appropriate for you, Mr. Letsolo, to say you can call a role anything. And you did say last time that I was getting into management space. I let it go. But this question is valid. So, is your position today that you do much more than just have a call account, as you told me last time? Are you changing your answer?
Chair, you're going to have to let me answer, because you see, one is you are making assertions about things I understand quite well and have done. You are saying a CIO's job is to maximize returns.
Mr. Letsolo, please start here. You gave an answer to this committee last time. Your answer today to the same question is different. Which version is correct?
There's nothing different, Chair. I'm saying it again. We have a call account, and that's what we have at the Road Accident Fund.
You don't have investments with anybody, not with the Reserve Bank, not with anybody.
Meaning?
Now I'm saying you may decide to take a portion of the cash that you have sitting in bank and invest it, because the Reserve Bank is mandated to do some of this work, for instance, or another institution. I'm not specifically au fait with your legislation. My understanding is that you are allowed to get into that kind of thing. So I'm not saying you shouldn't. But last time I asked you a specific question. And that question was, do you engage in anything other than running a call account? And your answer was you only have a call account. Now you've just said, just now to Honorable Atkinson, that you do much more than that. Wasn't that so? That's what you said. Please explain to me what more than that is in relation to the answer you gave last time.
I said, Chair, there is a view that all we do is manage a call account. We do more than that. I talked about certification of the loan book. I talked about asset and liability matching. That's what I said, Chair. So that's what I'm saying. We have a call account, but a person that is in a CIO position, currently the RAF does more than that. I said there must not be a view that, and I said it even in the last meeting, that there's a view that all people do is manage a call account, which is not true. Okay? So I'm saying, again, Chair, the RAF, so far as I know, does not have a treasurer, has never had a treasurer, it has got a CIO. That CIO does certain things, and I've said this, Chair, depending on the model you adopt, the different ways of looking at this person and his job description is totally different. So there can be a treasurer that does some of the work of the CIO in cases where there is no CIO at all, and then works under the CFO. That's what I've been saying, Chair. So I repeat again, we run a call account. There's not the only thing that the CIO does. There are duties and functions that are under a CIO that we do. So that's what I'm answering, Chair. I'm answering again. We have never had a treasurer since I've arrived at. I've never had a treasurer since we have arrived at RAF. So I'm repeating it again, Chair.
So, Mr. Lusalo, let me read to you what the committee's secretariat recorded of our interaction that day. And we don't have to delay ourselves, but I need to make clear to you, and I had made this point to the chair, that it is important that when people deal with this committee, they are truthful and consistent. So, these are the minutes of that meeting. The chairperson asked for clarity on whether the chief investment officer looked after the entity's call account, saying there needed to be a conversation on whether there needed to be a chief investment officer. He asked that the RAF send a submission explaining the need for a chief investment officer. Mr. Litsualo said that the chief investment officer would be needed when the RAF began to pay installments. The RAF was in the process of making changes, and the submission would lay out why a chief investment officer would be necessary. This is what the committee recorded that day. Now, I am not going to litigate the specifics all the way, right? But Mr. Litsualo, I remember very well that interaction of ours. The reason I raised the issue of a treasurer and chief investment officer is because you couldn't tell us what the CIO was doing. And this is what is recorded in the minutes of this committee. Let's not do that. Because you gave a different answer fundamentally to what you are giving now.
No, Chair. You have said to me, I said there is a treasurer there. And this must be in the record somewhere. Because you are the one that said to me, I said there was a treasurer. There's never been a treasurer there. There is a person who's acting in the position of CIO. And I said that person does totally different things. And I said we are now getting involved in the space of management.
Okay, Mr. Lutalo, you have not answered again. And I'm now making a statement, and we can go back to Honorable Atkinson. The answers you are giving today, and you know, one thing I'm going to follow up on is this full record of this discussion. Mr. Lutalo, it's not appropriate to give different versions of the same thing to the committee. And even on this occasion that you are answering, you are skirting the issue of this answer that I have just read back to you. That's the first thing. The second thing is we will, Mr. Litsualo, get into the issues of management, because when an entity tells us that someone has the title of anything but they perform something different, and if your version is that management is at liberty to decide on naming conventions and what those people do, and the committee may not ask questions in that regard, then we are going to have a conflict. I will ask the committee to send you both the recording and the transcript of the meeting. But this recollection here, because I've asked the colleagues there to send me the minute, because I knew I was not crazy. And your answer is inconsistent, sir. Mr. Atkinson.
If I may beg your indulgence, may I request that because the issue around the CIO would also be in the presentation as vacant and recruitment underway and position advertised, that at your discretion, the committee be briefed on the roles and responsibilities of each of the executives in order to provide a clarity on the matters. And that secondly, because this matter is arising for the second time around investments, that the committee be briefed around the activities taking place on investment, because I fundamentally believe, one, it will provide clarity, but it is of material, consequence, let me put it that way, to the finances of the entity, so that the matter can be clarified, notwithstanding the injunction that you have pointed to and the provision you will make of the transcript, so that clarity be provided. But I believe it would be to the benefit of the committee to avoid a back and forth on this matter. Thank you.
So, Honorable DM, are you saying that clarity will be provided in this meeting?
Well, I'm suggesting, Chair, that we may have to come back to you on that. I note, one, you would look at slide number 18. It speaks to the executive, the senior officials who must be vetted. They are all chief something in one way or the other as the executive. And therefore, it may be important that each component provide you with the work that it's doing. But I'm specific on the investment because it's the second time it has been raised. And what is clear is, substantively, we have not looked into whatever, or rather the committee has not looked into substantively the investment work, so that there's clarity about how it's structured and what it is doing, so that the oversight that you will play is in itself clarified for yourselves.
Okay. Now, thank you, DM. We'll in the course of the conversation, I want Honorable Atkinson to finish, but I remembered clearly the discussion that we had, and it's important that we have consistency. It's okay if things have changed, but we can't accept any version that gets given, depending on what day it is. Honorable Atkinson, please go ahead.
Thanks very much, Chair. Could I also ask why your CIO is not here today?
Chair, I don't know why there is a view that he's not here. The acting CIO is here today.
Okay. Thank you. Sorry, if you can just make clear who that is.
Mr. Sfutla Mudiba is here.
So I think your chair wants to say something, Mr. Sorry, Honorable Atkinson.
Thank you.
Thank you. Through you, Chair. I just wanted to add to what the DM is saying, that seeing that this position is still vacant and it's going through the recruitment process, I'm suggesting that we hold that process pending this discussion, because obviously there's going to be a reconciliation between the job description and the role and the current role, and until this matter is resolved. And let me apologize, Chair. When I was introducing the executives that are here, I actually omitted to introduce the acting CIO. He is in the room.
Thanks very much. I just want to move on to fruitless and wasteful expenditure. And I see the large bulk of your fruitless and wasteful expenditure is around the call center, which obviously you didn't follow procedures in the tendering process for getting that call center in place. Has there been any? Yeah, well, according to the financial statements, they said that you didn't follow the correct procedures for tendering for the call center thing. No,
I'm not aware of that. It's not certainly not in our. It is certainly not in our report.
Okay, as my understanding was that it was one of the items under fruitless and wasteful expenditure. Not okay. All right, I'm done with my questioning. Thanks, Chair.
All right, thank you very much. So let me ask this, the Honorable DM, you said you're going to a meeting. Let me ask the members specifically. So Honorable Skosana, you were not here. The Honorable Deputy Minister indicated that he has an important engagement. He's explained to me what it is, and I've
Chair,
given him the
I
discretion.
can stay until 12:20, I'm advised.
No, sure, that's fine. But having said that, I wanted to say, given when the deputy minister leaves, because we're going to move to Honorable Madlala now, I just wanted to give the members an opportunity to direct questions at the Honorable DM so that nobody feels shortchanged in the event that he then has, because I've given him leave to leave the committee meeting at that time. So I just want to be certain that, so what I will do is at approximately 12 o'clock, I will then just give the members, with the benefit of the conversation, to ask any remaining questions they have, so that at 20 past you can leave. Okay, thank you. Honorable Madlala, can I hand over to you? Have you been training?
Thank you, Chair. Thank you, and greetings to the colleagues. I don't know what Matuna is saying. Young lions are a problem. So I will go through the questions. There's quite a few, maybe comments that I would like to say first. I think we sit here and we go through quite a number of these issues. Well, there are contentious issues with RAF. I mean, issues that are being taken through courts and so forth. But we have seen worse in this committee. And I think sometimes when we try to correct some of the issues, we may seem as if we're not giving appreciation to the work that we are seeing done. And I think that there's quite a lot of work that is happening at RAF. Not that there are no gaps, but I see an entity that is engaged in the work of managing itself, and which is a good thing, which is not only just coming here with problems, but which also has suggestions to its own problems. And I think that is what we want. We don't want to be bombarded by problems without any suggested solutions. When we have people in entities getting paid, we want to understand their logical thinking at the strategic level of where they see these things going forward. And our responsibility as a committee is also to support them. And I think that you do have our support in some of these issues. Not in all of them, obviously, but in some of them you do have our support. So the first thing that I wanted to just check is, what are these timelines for these proposed amendments? Because I don't want to sit here in 5 years and hear that there's a problem with the legislation. And I like working on specific timelines. So we're developing an amendment bill, and this is at this stage. We anticipate to submit it to this committee at this date. And I like those timelines. It gives us a level of accountability, so that when we meet the next time, we can say, okay, this is where it's at. And if it is hogging somewhere, we can also be able to go to that person or to those people and say, you are halting a process that involves these proposed changes. But then it must follow the full plight, obviously, of consultations and whatever that needs to happen in that space. That's the first part. The second part is much referral has been made also in terms of the inaccuracy in the applications or the incompleteness in the applications. And this is in light of the presence or the existence of the lawyers in the space. And I think I did ask this the last time, but maybe it's important that I also gain clarity on it, because we consistently have a paradigm shift or an engagement that suggests that we would like to have a situation where we ultimately get people making direct claims. So if we've got this kind of gaps with lawyers present, what is the strategy of simplifying the process, and getting, or increasing public awareness on the expectations of documentation, so that we can if we get to a point where we transit and we get more direct claims, we can reduce also the inaccuracy levels or the gaps in incomplete documentation. And maybe in line with that also would be a question of whether the cost of marketing, which seems to have escalated, is it related to public participation or public engagement and awareness strategy in terms of trying to deal with that? Because I think I saw that there's quite a huge escalation in the marketing cost for the department. That will be the other question. And then there's an issue with the SIU, which relates to investigation of 102 law firms which had received duplicate payments amounting to approximately 340 million. And the several legal practitioners had opted to cooperate with SIU and sign an acknowledgement of debt. Has the remainder of the 340 million been recovered fully, and whether it has been recovered fully or part of it has been recovered? Signing an acknowledgement of debt does not exonerate the perpetrator from criminal action or any professional referrals. What happened after an acknowledgement of debt was signed, and were these attorneys arrested? I'm also quite interested. I saw a list of firms that have received the high payout. I'm also interested in a list of firms that are found to have been engaged in these unscrupulous activities, because I think it is important that we also, share that information with the public. On the Cienza project, which speaks to the claims backlog, it is alleged that the contract was awarded irregularly and unlawfully. What procurement processes was followed, and were there any deviations in standard procedures? Why was a service provider allocated to 2,472 files, but only managed to complete 96? Has there been any appointment to that regard? And maybe the last two questions will be on the procurement process in acquiring the office building at an estimate of 11 million, at an escalation of 6% per annum for 5-year period. Preliminary findings, and these are the information from the SIU. Preliminary findings, observations indicate that the actions are tantamount to overturning the decision of the bid adjudication committee, which is at odds with the legal prescripts. What is the status of the investigation on that matter, on that building acquisition, and the investigations thereof? Has there been any consequence management on the individuals responsible for this non-compliance? And the last question is on the RAF employees who are key to the investigation, are no longer in the, well, there are RAF employees who are key to the investigations who are no longer on the employment of RAF. What steps has RAF taken to recover funds and to hold those individuals accountable? That will be all, Chair. Thank you.
Thanks very much, Chair. Thanks, Honorable Madlal. Thanks very much for acknowledging the work we do. Sometimes when things are said, you'll just believe that probably it's not even worth it doing what you do. So thanks so much for the appreciation. We hardly ever get any remarks like that. So thank you so much. What are the timelines for the amendment bill? Well, it was withdrawn. I can't answer that going forward. You must know that it's in the area of policy and legislation, which falls within the the executive authority. The inaccuracies with the application. Look, much more of these issues of information that we require in claims and the inaccuracies thereof seem to be by design, not default. It's not as if people don't know what they need to put in and all that. We believe that they want to abuse Section 24(5), where you can't make an offer and therefore they must go for summons. And that claim will be valid in all respects in law. You can imagine having something that is empty, but you're having 60 days within which to do it, which is why we're rejecting most of those claims, as it were. The issue around direct claims, right? So, if you read Section 19C, you're going to see that in reality, you can't really do direct claims under the current dispensation. Because the expectation is that if we do not react within the 120 days, we must issue summons. I myself sitting here, I'm not uneducated. At least I've got a certain level of qualifications. I don't think I can draft summons. So you can imagine someone else who is an ordinary person in the street, not having a qualification that it may be, you know, trying to draft summons. So you fill in the forms, which forms, by the way, are very technical. So it's not meant for the people. People will just go through a process and they just get frustrated by it and then they get out, as it were. And the direction that we are going, we are saying this must not be intellectually based, meaning it must be like SASA, you must apply. The thinking of getting a lawyer going to court must not even be part of the system itself. And we are saying to the extent that at some point you have frustrations, there must be an independent adjudicator that can adjudicate over that. There are pension fund adjudicators, there are other adjudicators. So people don't necessarily, for adjudication of cases, need to go to court. That's what we are saying. I think I'm going to allow the SIU to answer the other issues because some of them are SIU. For the procurement of the I think it might be here where a decision was taken to review this thing was at the time of the procurement of the head office building, if I remember well. So when we arrived in 2019, there was a tender out for procurement of head office building. And at the time, I remember we did a review. The review was saying they wanted, I think, to move to the next building. There was 120 million that was required for TI, which is tenant installation and other things. Moving out of the building, I think there was also a part where the IT reticulation and all those things were supposed to be done in another building. And we felt at the time that the RAF could simply not afford that at that point. And we then decided to discontinue with that procurement process. So I don't know whether it's an issue of investigation or what. We'll answer that at that time. So you are saying it's preliminary, we'll wait for whatever the findings are so that we can deal with those findings. The list of unscrupulous activities, there are many. I think there are a lot of them that we have reported to the LPC, these law firms, as it were. We receive nearly daily unscrupulous law firms that they might not have defrauded the RAF, but they defraud the claimants in the main that we receive, and we do assist those claimants in trying to register these matters with the LPC, which I must say has not been very helpful. It will help Chair to bring the LPC here so they can explain some of these things because it's very difficult to understand how they operate. Sometimes we try to apply.
We will bring them, believe me.
Yeah.
They must come here.
Yeah, there are times when we apply for these people to be struck off, and they are the ones that defend those cases. So maybe they must explain why they defend those cases. They would actually explain that to you. I hope I've touched, cost of marketing, yes. The cost of marketing, if you look at what happened in RAF, when we started from 2019, 2020, 2021, we were quite internally focused. Then in 2023, I think that's where we started to actually expand more, get people to understand what we are about. As well, the call center, it had to be marketed so people can call into it and all that. So there has been a lot of money spent on marketing and communications cost over the last 2 years. So that's related to this. So it also deals with the issue of public awareness. People must know their rights. I mean, for instance, this party cost, people don't know that they're entitled to it. So these lawyers just take them and then they walk away with them. And there's been 4 years that they've been doing that. So those are some of the things that we encourage our people to be aware of. So we do a lot of activities that are related to public awareness. Thanks.
Thank you. Can I just get the because the DM, I think It's not up to you to answer the question of the legislation and when, and maybe the DM needs to provide Honorable Madlala with an answer. But did you want to complete something amongst yourselves? Okay, please do. And then Honorable DM, if you can answer the question about the amendment.
I just wanted to deal with the issue of project sense. I think it's a matter that is seized with the SIU as well. But what had happened is that they had our predecessors had hired a service provider to come and help us with facilitation of settlement of files, and that was found to be unlawful at some point, and I think the AG has found that there were issues with that contract. And I think something that was handed over to the SIU because we had a forensic report and it got to a certain point and it got stuck and it could not go forward, and we thought that the SIU has got better capacity to handle that. Thanks.
Thank you very much. Honorable DM.
Thank you very much, Chair. So the decision to withdraw the ref amendment bill has been taken a few days ago. And as indicated earlier on, ref has been advised of that decision and our intention to reintroduce the REPS bill. In the correspondence, I have indicated that REF is going to be given an opportunity to make its own submissions. I await a response. I've heard what the chair has said in her opening remarks, and I would imagine correspondence will reach us in due course. And therefore, what will happen, Chair, is once REF has applied its mind to what we are placing on the table, we will develop the timeline. But I will hasten to say, this is not a new bill. And therefore, a lot of work has gone into it prior in any case. What I am mindful of is that the ecosystem in which REF operates has fundamentally changed. There may be new ideas and a fresh set of eyes to the prevailing realities, and therefore that will be factored in. And at that point, Chair will provide the timeline. It is my assumption REF will want to consult legally and apply its mind legally to the policy direction which we are pointing to, and we will provide that timeline, and the bill will serve before all the statutory bodies it must, including cabinet, and we will therefore then bring it to the portfolio committee accordingly, as we should. I have in consultation with the minister, advised the leader of government business in the course of work that he is doing to constantly update Parliament about legislation, pending or otherwise. What I will commit to Chairperson is that this is a process we will seek to expedite and for it to receive our urgent priority attention, given the myriad of problems which we are currently confronting and therefore seeking to solve with this bill. I have intimated to the chair that we will have a board meeting in earnest because, amongst others, I don't think that it is healthy for us to be just speaking through correspondence. We'll have to have a discussion and engage, but it was necessary to formally advise REF of the decision taken to withdraw the REF amendment bill and reintroduce the REPS bill, and that is the process we will do. So once that timeline has been finalized and REF has applied its mind, we will definitely keep the committee abreast of developments in that regard. Thank you.
Thanks, Deputy Minister. So, we need to save time here. So what we will, I will ask you to do in writing for the committee, because the portfolio committee processes legislation, but the issues that you are trying to deal with are pertinent to the financial health issues of the road accident fund. So we will just explain to you maybe the nature of the memo you send to the committee, which we'll distribute to the members just to get a sense of kind of at least the reasons for the withdrawal. You don't need to litigate it here and so on. You dealt with the issues, but I think it's important the members are adequately informed of the issues involved. Honorable Madlala, you may have a follow-up, and I want to give you that opportunity.
It's just going to be two follow-ups. The one is, in fact, to the CEO. I want to just get your confirmation that, you know, I like the thing that you are saying. You don't come to ask for more monies generally. And that's a very good thing. You must find strategies in which you sustain yourself. So you are saying that despite also the fact that there was no levy increase, you're still not coming to ask for any money within this financial period. Is that the case?
Yes, Chair.
No, thank you. Maybe to the Deputy Minister. I just want to, because maybe you've spoken of RAPs, the withdrawal and then the reintroduction of these things. But I want to just deal with the elephant in the room, maybe in a nutshell for the interest of the public as well. There is because I would like to pick your mind on this, to get what is your opinion on it. I don't know if you're in a position to do that. There is a perception out there that the much fight and battle between RAF and this entire thing of how it is determined or seen has to do with the big corporate white law firms, which have been beneficiaries of RAF more than the people themselves. And the battle then on is for the sustainability of that beneficiation or that looting spree by these law firms at the prejudice of the people on the ground. And I found many submissions by the CEO of RAF logical, beside in the current stage whether it is legal to proceed and not comply, which is a separate matter. But I'm saying in a long term, there are logical arguments presented around how RAF should be structured, so that we're able to mitigate and ensure that the end users, the ultimate beneficiaries, are the ones who benefit at the receiving end. So the review or the reintroduction of RAPs, does it change anything in that context? What is the view of the Deputy Minister around, not now, whether compliance or not, but future projections, and looking at RAF as an entity for its own sustainability, whether as an insurer or as a social grant? I wanted to just make that. Thank you.
Chairperson, this conversation will require a full day, because I think what I have tried to present to the committee is the prevailing dilemmas at play in this meeting and in the previous meeting. One, we've got a funding challenge, and I've indicated the interventions which we seek to do in that regard, and the exploration of other revenue streams, and to engage Treasury that the withdrawal of the ref levy at the pumps is not something that can be considered at this point in the absence of a concrete plan of how we're going to fund ref. Therefore, the funding model of ref is at the upper focus of what we want to do. That's point number one. Secondly, I've indicated that it is my suggestion in my opening remarks that the LPC be called to this committee to explain itself and its own conduct, and that of the professional fraternity in its entirety, to deal with, amongst others, challenges which seek to say monies do not reach claimants. And I mean, I'm sitting day in and day out with a stack of correspondence from South Africans. And REF will return and say that monies were paid out and that money went to the lawyers. So it's logical, Chair, that the key question around lawyers must receive the priority attention of any review. I've engaged, as I've said in my opening remarks, with some of the law professionals. In one instance, I called the CEO and pulled him out of one meeting so that I could provide real-time responses to some of the issues that and the health practitioners, by the way, because it's not just the legal fraternity. There's also the health practitioners whom we need to deal with. And hence the reference I keep on making around the implications of the NHI. The third point, Chairperson, is what I've already indicated and the CEO has elaborated on further. Paying lump sums is not sustainable for the claimant nor for REF, given the financial challenges we have of revenue streams for money. And so as we go to this review, one of the things we need to do is to define the benefits. A class issue, a race issue has been raised, but more so a class issue around the actual estimations and final products which come out as to whether Hlengwa's arm is a 10 rand and Joe Soap's arm is 50 rand, right? So those are all the critical issues we need to look at. And therefore, when I make the statement that REF is not a money-making scheme, it is meant across the board. It's not a money-making scheme for lawyers, it's not a money-making scheme for health practitioners, and nor is it a money-making scheme for the claimants. So those are the issues we need to deal with. It remains my outlook that if you win the lotto, right, and every time the Powerball reaches 100 million rand, somehow someone wins it, I'm advised that before you get your money, you get some sort of counseling, right? So whether we're paying lump sum or we're paying in tranches, there has to be a semblance of also financial counseling for how claimants actually will utilize their money so that we can prevent a situation which prevails like in the lotto where people then say, I blew it, because then they come back to us. The other consideration is that there's long-term medical effects which arise as a result of an injury or as a result of the accident, which then are brought back to REF in one way or the other where they are expected to deal with. The final point is the reforms we seek to do, amongst others, seek to say, how do we ensure that the right claim reaches the right South African claimant? You cannot have a situation of porous borders as we do, and by being in the country illegally, you get a full-scale benefit of the provisions of the country, whereas you're not paying tax in any way. You are not contributing in any way. So these reforms must be looked at from that particular perspective to say, in the last meeting, REF pointed out to the fact that we have Americans claiming us hundreds of millions of rands because the actual calculations are done in dollars and therefore when converted to the South African rand, they're astronomical. And I think it's 3 Belgian doctors, right? Amongst others. So those are all the considerations that we have to make. What this requires is engagement with Home Affairs on visa requirements as well, which must seek to protect the South African economy and the South African government's interventions, including but not limited to what REF does. Finally, Chairperson, we cannot therefore look at the dilemmas at REF in isolation to what is happening in the road sector in its entirety. And so we need to be imaginative about streams of revenue. The trucks we have on the roads, pulling all sorts of goods, need to be taken off the road. So the road-to-rail system is critical because it seeks to, amongst others, deal with accidents. You look at what I was pointing to earlier on. Chair, South Africa is number 5 in the world for alcohol consumption. The World Health Organization's report. Now, what are the social implications of the high levels of alcohol consumption? At what point do we begin, Chairperson, I dare say, apportioning blame to accident causes? To what point do we begin apportioning blame and responsibility to the ones who are giving us accidents, whether it's road users? I mean, if I am going to walk where I'm not supposed to walk, the key question, and then I'm involved in an accident, drive where I'm not supposed to drive, it should not be automatic, right? So that you are a ref claimant. So, Chair, what I'm saying is that, yes, the issue of lawyers is a problem, but we need to expand the scope of our dilemma, that it's not hinged just to one reality. It's an entire ecosystem of problems which we seek to actually resolve at this point in time.
Thank you very much, Honourable Deputy Minister. I'll come to you, Honourable Atkinson, just now. I just want to say to you, Deputy Minister, and the Chair, and the Chief Executive, because as we discuss these matters narrowly that we deal with, like many other issues, and I'm really glad with your input. I'm happy with your last input, Deputy Minister, because the Road Accident Fund sits at the apex of everybody's problems, and they manifest themselves as claims into the system. And in a sense, I'm not certain there will ever be a model that takes care of the problem. There is the issue of driver behavior. When you mentioned the number of accidents that we had in December versus the number of fatalities that we had, it speaks to a multiple vehicle occupancy accident issue. Buses, taxis, cars with lots of people, and so on, and there is an issue. Unfortunately for you, Honourable Deputy Minister, all of these problems, most of them sit in your portfolio. We can talk about alcohol and these other things, but I just want to say, especially to the public, as we discuss these matters, for me it is clear that we can't look to the Road Accident Fund to solve bigger problems after the fact. That's just not sustainable. I am also glad that we're going to deal with the issues of how non-South Africans are catered for by the legislation or not. I have no expectation to be paid out in the UK when I go there. They ask me to take medical insurance, and that's that. We will have the Legal Practice Council here. They absolutely must come here, because there is also a moral obligation on people, and a legal one, to do right by those claimants. And finally, I think one of the things we must all be able to kind of communicate accurately, that there are policy issues, legislative and policy issues, which is where the amendment of the legislation is concerned, and there are also the funding challenges. And the last thing I'm going to say, which you know very well, we all celebrate when the finance minister says no increase to the RAF levy. The problem with that is that on the other end, lots of people sit and say there's no money to pay me and I'm unhappy and so on. And I'm hoping that this is a teachable moment for all of us in terms of just how we understand the interconnected nature of the issues and the complexity. So to you, DM and Chair and CEO, we do not underestimate the complexity that you're dealing with and the difficulty of the issues. And I think it's work that has to be done under severe stress and public attention. So, Honourable Atkinson, you've put up your hand, and now you are double dipping, because you had an opportunity to ask questions for 20 minutes.
Yeah, it's my follow-up. I never had a follow-up.
Oh, you never had a follow-up?
No,
okay,
no.
My apologies. Okay,
Thanks.
I will allow you.
Okay, so just going back to the point where I mentioned about the fruitless and wasteful expenditure, I see a regular expenditure under determination at an amount of 68 million. And it's described as an incorrect price evaluation was conducted in contravention of Section 8.1 of the preferential procurement policy, blah, 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 blah. But I'm sure you'll know if there's 68 million rands worth of irregular expenditure under investigation as to exactly what it is. And I'd be interested to know what that is.
Yeah, Chair, it must be SENS. I mean, I'm not so sure. Bernice will deal with that.
Sorry?
The CFO.
Okay. Okay.
May I beg your indulgence momentarily if we can park that and deal with what you had said would happen. I'm just mindful of time. If
Or
there's
your
any matter, yeah,
time to leave.
Then I'm sure then that the CFO can then come in.
No, I think it's just confirmation what the CFCO is saying it is because that information is provided in some of the supporting documents, Honorable Atkinson. So, CFO, is it the Cienza issue that is in reference here?
No, Chair. The Cienza one, I think, is closer to 400 million, if I'm not mistaken. This is another one that was identified, I believe, as part of the audit, but it is still under determination, and it will be reflected in the annual report once it's been concluded, as far as I know.
Do we know what it's for?
Chair, if you give me 5 minutes and we can finish, then
Okay,
I will
let's
give
come
you the
back to it.
feedback on that.
All right, no, thank you.
Okay, and then
Let's
just
come back.
one final question for the record, Chair, is just to ask the chairperson if everything with regards to the call centre, the call centre contract, whether that was all following proper supply chain processes, and it's all entirely above board. We'd just like your answer on that for the record. Thanks.
No, Chair. As I say, all our processes get audited by the AG. So far as the audit has gone and everything else, everything was above board.
All right, thank you very much. I just want to just be certain, do any of the members have questions for the Deputy Minister, because he's leaving at in 11 minutes. So Honourable Mende has a question and Honourable Esak has a question. Only for the Deputy Minister, please.
Thank you very much, Chair, and good afternoon to everyone. No, Deputy Minister, I just want to get an understanding and also suggest, given that there is fundamental differences in the two bills, the one for RAF and the other one for SAP. Now, you are saying they do have a window within which they are going to make their own submissions, given the current prevailing environment and the things that they are dealing with. So I want to understand if, are they going to be able to include everything that they felt is helpful? Because I listened to the board chair earlier on that they are trying by all means to find a space within which you will understand each other, or rather meet each other halfway, in order for their complaints and concerns be addressed, but equally having whatever the executive had in mind back in 2017 when they introduced that other bill. I want to understand if you are going to give them that kind of an accommodation, or it's just a submission that should not be limited to, that will be limited to certain aspects of the bill. Because if we look into exactly what you were addressing earlier on, we're required to take insurance when we travel to other countries. And that's one of the aspects they were trying to address. So are you going to take their bill as it was, infuse it with yours, or rather change a name or whatever, or are they going to be limited to certain aspects of it? Thank you.
Thank you very much. Honourable Skosana.
Thank you, Chair. To the Minister, I just want to ask one quick question today because of time. My question, Chair, would be, why was the Road Accident Fund Amendment Bill withdrawn? The number 3868, which was published in the Government Gazette of 49283, 8 September 2023. Thank you.
Okay, Honourable Esak, and I'll be cognizant of the fact that we've litigated at this point, but Honourable Skosana wasn't here at the time. Honourable Esak?
Chair, thank you. Yeah, mine is just a very simple question to the DM. DM, look, with due respect to you, sir, both you and the Minister are obviously spearheading this department and obviously take accountability in terms of the executive for the workings of the Road Accident Fund. My question to you, sir, is very simple. Are you going to advise the Road Accident Fund to abandon their court case that they are spending millions on, going nowhere? The fact that it is a state entity, this Road Accident Fund is a state entity. You as Deputy Minister surely need now, with the Minister, to take a stand for South Africans as a whole. So I'd like to hear your comments in terms of what advice are you going to give the Road Accident Fund in terms of this litigation that's been going on endlessly. Thank you, Chair.
Thank you very much, Chair. Honourable Mende, yes, the Road Accident Fund, well, maybe let me start here. Policy and legislation remains the function of the department under the leadership of the ministry. And this is a reality for all our entities. So the Road Accident Fund, as I've indicated, I've written to the chair, and we have indicated to them that yes, they must make their submissions. They are the first point of call before we've spoken to anybody. And we will look at their submissions and we will take the policy decision on inclusion of matters and framing of things. For an example, there's certain issues that the CEO has referred to which are prescribed in the law, which should be in regulations. It's elementary that those things need to be fixed in order to provide the necessary agility and efficiency for RAF to be able to perform its core mandate. Again, as I've already said, Chair, there's areas around direct access to RAF. I mean, in slide 4 of the presentation, the Road Accident Fund speaks about the block settlements, which is an attempt to be able to go out to communities, to the public, and be able to interact and deal with these issues. So those are all matters that you have to look at, but it's incumbent on RAF to look at REBs and provide the submission that they want to make. I have also committed that I will engage with the board in earnest at a mutually agreeable date in this regard, and that we are going to do. So that conversation will definitely take place. But of course, Chair, I must hasten to say a submission is a submission. And we will wait against the backdrop of the policy direction that we seek to take. And I'm pretty certain, Chair, as an interested party, as this committee, we would have no problem coming to brief the committee on the nuanced detail of what we seek that we want to do. I think I've tried to today, but if it's necessary, sure, we can come back. I know how long the REF matters have been before you. Why was the bill withdrawn? I think I've explained, Chairperson, and the honourable member can be furnished with the record of the meeting and the minutes. Suffice it to say, it's a policy decision that has been taken, and we believe it is in the collective interests of REF and South Africa, and we believe that it is a bill that had been tested in its material facets and reached the floor of the House. And we all know the circumstances which surrounded the voting. It was something that, well, was for that time. But we are also cognizant of the fact that times have moved. There's new thinking, there's new ideas and new conventions, which will be catered for in the public participation process as ordinarily any bill should do. So we'll do that. So That's that. I think I've been at pains, Chair, to explain this. Sorry, Chair, at pains to explain the ecosystem as we see it and what needs to be done in that ref. Because also, Chair, I think what we need to do is narrow the scope of us and them. Ref is an entity of the department. 98, so it's not some far distant removed entity. That's why we're starting here on the engagement. That's the policy direction we are testing them as the users. They must, but the centrality of the department and led by the ministry to lead policy and legislation must hold. And then finally, Chair, have we advised? Yes, we have. I've communicated the position of the ministry on the court action. I've repeated it here in the previous meeting. The CEO has indicated to you that they're in receipt of correspondence from the executive authority on what must happen, and I'm certain a response will be provided in that regard. The bottom line, Chairperson, is this. We believe that the changes to the accounting standard, as they have been explained, must be done within the parameters of due process and the law. This matter has been tested not once, not twice in a court of law. But, Chair, it's one part of the ref challenges, right? So that's one matter. Because what the perception that must not be created is that we are opposed to any court action that ref does. On the SARS matter, they've informed us that they are going to court, and I've been agreeable to them testing their legal options insofar as that is concerned. Right? So this is an issue by issue thing, because that's the nature of a relationship. And we'll await the outcome. But on this one of the accounting standards, I think our position is very clear and has been communicated very clearly. And we will consider our options when we look at the responses and whatever comes out of the court process. So it's a matter that remains very much within our purview. So, Chair, in conclusion, let me say this. We want a ref that works. And we need to put in place all the enablers for ref to work. It has pointed to numerous challenges. It has pointed to perceptions which may be out there. We are making the necessary efforts. That's why we are engaging DOJ with them for the processes around the Gauteng division. That is why we are going to National Treasury with REF, initiating these meetings so that these hard discussions that REF needs to have with the people who must take decisions, we must have them. So we are there to support REF. We are there as an enabler of REF. Because the bottom line, Chair, if REF fails, then it means we have failed. And so the issues you are dealing with require a collective effort. And what I said the last time, I reiterate. We will have disagreements. That's the nature of the course of work. It would be highly peculiar if we didn't. I've never been married, but I'm told that in a marriage, there's differences there as well. And it takes a lot for you to arrive at a divorce. And well, we're not going to be divorcing REF. And I think that the bottom line is we have more in agreement with REF than we do in disagreement. And so ours is to give REF support. And ours is to lead the policy strategic direction of the department and of the entity and the sectors, and that is exactly what we intend on doing. And Chair, I think there must be an appreciation. It's a difficult space to navigate for REF itself because there's a number of issues which are out there, and I think they've been ventilated sufficiently. What's important is to respond to them with concrete action steps. But yes, we have, Honorable Isaac, yes, we have communicated, REF, that it is our position that they should not be in court. And we will await whatever is the outcome and take a decision on the basis of what will be presented so that we can bring this matter to a logical governance conclusion. Thank you, Chair.
Thank you, Deputy Minister. You are released from the proceedings, but only you. So I think, I've tried to avoid this issue because it really is in court. I think what we need to do for as the committee is to take account of the actual outcome, the conclusion, and the comments of the court, and then we take a decision about what to do in that regard. But my frustration, in inverted commas, is that we keep having this conversation here, and it, in a sense, it helps people to understand. But we're not going to be able to resolve the issue here ourselves, in as much as we. But Honourable Skosana, was there an issue?
I just wanted to make a follow-up, though it was not my question. But I remember, as you said now, Chair, that this matter is coming on timelessly here. We'll wait for the court to come. But I just wanted to say that the court granted an order as well. In the matter between SARS and REF. And it's not a secret that indeed it helps to go to court. As the Constitution allows us, if we are not happy, like any other institution, to go to court. I just want to emphasize that and be recorded that there's nothing wrong that prohibit.
You're welcome to make these comments. Remember, there's a 20 past. The deputy minister has to leave at 20 past, and all comments are for his. And I think he's done with us now.
No, Chair, it would be remiss. You see, I was the one, me Mkhuleko Mangaliso Hlengwa, at the outset of this meeting, who said REF has gone to court on SARS. There's an interim court judgment. We are waiting a final court order at the end of the month. Me reporting here. I'm the one who has said, REF came to me and told me there's a 5.1 billion rand problem. We explored the option of IGR mediation. When it failed, REF said they're going to court. I was agreeable to that. So there must not be a selective reading of reality.
No, Honourable Hlengwa, so I was going to say that, Honourable Skosana, I was going to deal with the issue and let you go because he was in another committee meeting. I don't want us to keep litigating the issue. That's why I'm releasing you. Then I can explain to you are really free to go. I was going to say, Honourable Skosana, this matter, before you joined the meeting, was ventilated in detail. We understand what it is. We understand that there's an order and so on, and the committee is very well informed. You were simply not here at the time. So what you are saying is well recorded, and nobody's in dispute with it.
Thank you, Chair. My thousand apologies because I was not here. My only worry was that this matter is coming on, and one lawyer who was sitting here, I was not even aware that he's a lawyer because I thought it's a departmental staff, came to me and accused me to say, why am I objecting about the issue of these claims that people should go through lawyers? Now this issue, when it's coming now and then to say, no, people should not go to court. No. People should go to court.
No.
It's as simple as that.
I mean, the committee and the minister, I think there was only one issue where there's a dispute. Otherwise, the deputy minister has affirmed the RAF's right to take matters up in court, and that they are supporting them. They've given them the room in the SARS matter, for instance, to take it forward. So,
any matter, Chair, any matter.
So can we? No, Honourable Sak, I don't want to cause any more. I don't want to cause any more issues. We are running out of time. We're running out of time. Please, members. Okay. I nearly said please take it outside, but can we have order in the... Can we have order in the... We have guests here, members. We have guests here. We need to maintain decorum. We don't want them shaking their heads when they leave here. Please. Please. Let's fight when the guests leave. The cameras are off. CFO, is your hand up, or are you going to deal with the outstanding question?
Chair.
Okay.
Thank you, through you. So, Chair, this particular one, sorry, my memory failed me a bit. It was an award of a contract for a fleet management solution. The award was made in 2014-15, and then in about 2019, there were some issues of improper conduct by RAF employees in managing the contract, which was then referred to a firm for a forensic investigation, where then improper awarding of the contract was also, in addition to the improper management of the contract, identified. Those employees were disciplined, the responsible parties. The contract has also been referred to the SIU for investigation, so it's the fleet data one. Thank you.
Thank you very much, CFO. So here's what we'll do. Honorable Esak, can we have some order? So here's what we'll do, and we're going to work with you, Chair of the Board, and the Ministry, because one of the things I try and avoid is having government agencies coming here every now and again, then you can't do your work because you are always here. So what we'll do is we will coordinate with the SIU to do a presentation to the committee. They've provided us with an update. There are some matters which from their processes need to go through one more step, and then they're able to give us a full story. So what we'll do is, once those matters, they've reached a stage for the SIU where they've reached definitive conclusions, we will then have a discussion with the SIU and with the Road Accident Fund. We will also try and make it, in terms of your schedule, try and work with the other committees you may be appearing before, so that you just hear once and you don't have to keep, doing a back and forth. So we'll try and accommodate you in that way. And some of these matters are in that it's been furnished to the members, the document I'm referring to, the update from the SIU. So let's park those issues so that we can deal with them properly, but we'll try and do it in a way that minimizes your schedule, the difficulties on your schedule, but you're also still able to account. Honorable, I'm gonna now try and run a process that takes us to 1 o'clock so that we can release both the members and the guests. So I'm going to start this. So Honorable Atkinson, you are now out. Honorable Madlala, out. Honorable Skosana G, you are out. The only members is Honorable Esak, Honorable Nondenja, Honorable Maduna, Honorable Skosana, and Honorable Mende. And I'm repeating them because they asked questions specifically of the Deputy Minister. So we're now directing questions that the Road Accident Fund may please ask that we are concise in our questions. We are then going to take you, Honorable Esak, Honorable Nondenja, and Honorable Maduna, give the Road Accident Fund a chance to answer, and then we take Honorable Skosana and Honorable Mende and myself, and then we are done. I'm really keen to release all of us on. No, you're out, Honorable Madlala. Sorry for you. Sorry? Me? Look, what typically happens, members, what typically happens, by the way, is that we run out of time before then I leave it. So that may happen today. Honorable Esak, please go ahead. And can we just be concise, members? I beg of you. Let's be concise. Ask the colleagues from the Road Accident Fund concise questions. They will answer concisely, and then we can respect our schedule. Thank you.
Thank you, Chair. I appreciate the opportunity. I promise I'll be very concise with the questions. I have about 4 or 5, but it's going to be very concise. I'll cut down the explanations and the trimmings. Okay, so the first one I'd like to just inquire is, I'd ask if you could please outline any disciplinary actions that you are currently conducting against any officials for irregular expenditure. Concise enough, I think, Chair. Second one, I'd like to understand, through you or your team, in the report that I have studied and read last night, it speaks of other costs that are what is implied by other costs related to claim payments. So under claim payments, you specify other costs. If you could just educate me and explain to me what is implied by that. Then, Chairperson, number 3. The Road Accident Fund consulting and professional fees increased in the last financial year from 70 million rand to 245 million rand. Okay? So I'd like to get an understanding in terms of what happened in a 12-month period from 70 million to 245 million. It's just somewhat mind-boggling for me, but maybe you'd be able to explain. And if you don't have a detailed reply, Chair, through you, I would like if the Road Accident Fund then give the committee a detailed breakdown so that we can see exactly what happened from 70 to 245 million in terms of the irregular expenditure, so we can interrogate that. Then, Chair, last two, my understanding to the CEO is that, and correct me if I'm wrong, my understanding based on what I've read is that you're currently playing a dual role in that you are the CEO currently, but as well as the Chief Claims Officer. Am I correct? And then lastly, Chair, the Road Accident Fund employed a specialist security officer, which you took over from Transnet. I'm sure you'll recall that one. What is the specialist security officer? What does he or she really do? Thank you, Chair. I'm done, and I was concise.
Well done. Thank you so much. Honorable Nondenja.
Thank you, Chair. The public entity lost 246 employees, with most of them being skilled and professionally qualified individuals. What impact, if any, have these terminations had on the business continuity? What are the prominent reasons for terminations? And are there any talent retention initiatives at the REF to avoid the loss of institutional knowledge and skills? The last one, Chair, is the board chairperson and the deputy chairperson have been with the REF since 2019. In their view, has the board been effective in implementing the strategic 5-year plan, given that it is in the final year, in the 5th year and final year of that strategic plan? Thank you.
Thank you, Honorable Nondenja. Honorable Maduna, as you land.
As I learn, Chair. No, thanks, Chair. Good morning. No, good day, Chair. No, Chair, I'm also not going to be long as well. And perhaps in the words of Honorable Madlala, we must commend the work that is being done at RAF. Historically, it has been proven that it's not easy to deal with a monopoly. And I think what those 10 or that draft that is giving us, whose are the lawyers that are benefiting or attorneys that are benefiting or benefiting more from RAF, it gives you an idea who are they exactly fighting with. You see, Chair, historically in South Africa, a monopoly has a color. It's different ours. And we're usually afraid of saying these things. A monopoly of South Africa is white, and it also has a gender. It is white male. I can say to you now, I don't know who owns the most benefiting attorneys from RAF. But if you can go to that debris or what, I'm sure it's owned by white male. That is the story of South African economy. And I just wanted that we must commend them for the work that they are doing there.
Dibrolio is a closer surname, Honorable.
It's not possible. I'm just saying, Chair, it has been proven over time. There's nothing you can do. It's a South African situation that we must face and accept. Because I think at times we become unfair in terms to white females in South Africa. The monopoly of South Africa is white, is male in particular. Chair, not entertaining those questions. I know there are many.
When you call the member to order, please land here.
As I learned, Chair, I only have about short 3 questions. One, The first question is on the. I see on the litigation you are decreasing the spending. Perhaps the what would be the trends are decreasing. Perhaps what would be the cause? And I think it's something that must be commended when you spend less from time to time. Okay, I think I've spoken on the issue of top 10 and also the issue, the steps taken to combat claim systems abuse, financial controls and governance. I just wanted to check on that. The report mentions that you had about 4,031 claims blocked for various reasons. Can you perhaps expand on that? I heard that you spoke on it, but can you go further? And also, I just wanted to check, when do you anticipate the conclusion of these matters by your forensic unit? Yeah, and I think lastly, the steps taken to combat system abuse. Obviously, you told us that you had about 38 claims. I think, Chair, this some time back when RAF was last year, I spoke about the issue of lawyers. Of us in South Africa having corrupt lawyers, and I think particularly almost 50% of program of RAF they arise from this. And we have made a conclusion, Chair, as I learned that you see the frivolous and fraudulent claim by lawyers and exacerbated claims, they lead to financial losses for RAF. Secondly, the issue of overcharging and exorbitant fees. I think it's what exorbitant fees is the issue that we're talking about, that claimants end up not getting what they were supposed to get, but majority ends up with these lawyers. And also, this issue of lawyers in the process also contribute towards ensuring that there are delays, and then it causes some obstruction. And lastly, I wanted to make this comment, Chair, as I learn. I went through some judgments. You see, just the judgments that you will pull off the internet in relation to case of RAF. And I think one thing that I noticed, they appear, I don't know, CEO, I would love your comment. They appear to be some inconsistencies in terms of the judgments. And when I was reading it from this one to this one, they appeared to be very unpredictable in terms of the conclusions that lawyers tend to make on claimants of RAF or the cases that they deal with. I think, Chair, that was that from me, and I think it's very important that we must ask the legal practitioners. They must come through, Chair, and come and explain the conduct of their people. Thanks.
No, thank you very much, Honorable Maduna. We will. So, Mr. Bowman here is already, and no relation to Bowman Gilfillan, the law firm, by the way. He's already on that letter to the LPC to invite them to come. Chair and your team, over to you. Or you want to do all of us? Okay, no, that's fine. Let's do one, and then we'll give you a chance. Okay, cool.
Thank you, Chair. I just want to say one. You know, the money which you recovered from attorneys, sheriffs, as well. With that mandate, that there was 340 million and you recovered 317 million. I just want to say, thumbs up. Normally, with some other committees, with the SIU as well, they struggle to get money back from those corrupt big boys. So for you to have done that, I guess you've done well. And the issue from the CFO, I guess on this fleet management question, when you ask why was that fruitless expenditure, you said in 2015. My question would be, do we still have anyone here who was with RAF in 2015? Or are we talking about people who left, who have messed up, or we still have those people here? On the fraudulent claims, which I think my colleague has asked about, there was an attempt that there was an issue of people wanted to change a bank account. What is the total financial impact on that fraudulent claims from all these employees who are, if they are still employed with REF? On the amount currently held by one major bank, the 15 million rand, Can you perhaps provide us with that name of that particular bank? Because the SIU, I guess they should have, at least by now, provided that to you. Or the CFO knows exactly which bank is having that 15 million rand. My last parting shot, Chair, because there's no time, I'm looking at the time. I normally wanted to ask a lot of questions because, as I said earlier, Chair, that these scrupulous lawyers, both black and white, there's one who was paid 15 million, he paid the claimant 750,000. I'm talking about a professional here, and people will always say, perhaps I'm not against professionals. But indeed, I'm talking about an attorney who, he's heartless. How do you pocket 14 plus million rand into your pocket? Now, to the board, as I learned, like my colleague is learning, I want to say to you as well, personally, I know this so-called personal cost that you must pay out of your pocket. And to the CEO, if I remember, that by taking that case to the Supreme Court of Appeal, you've done well. And I'll always say that on record, that in any matter, if as the board or the executive, you feel the matter has to go to the highest court in the land, so be it. Thank you.
Honorable Scotland, I thought you were going to say if there's a personal cost order against him, you will cover them. But you did not. I was waiting with bated breath, and then you just off-ramped, Honorable Member.
But you can't just speak anyhow.
Thank you very much, Chair. No, I think today was one of those refreshing days where the depression is not that high. We are usually very depressed by numbers and figures. And then one thing I would like to say before I ask my questions is, for a while, especially after the dissolution of the panel, RAF has been a subject of ideological battles. So my colleague has termed it correctly that the white monopoly capital has come with tons of bricks over you. But then it's because of the system that was designed, which we seek to change now. And I want to say both the board and the executives led by the CEO, you should not be apologetic, because this is a terrain within which many people have utilized the black government of South Africa as coffers to be stolen. Thuggery and thieving had been thriving in our government throughout, and RAF was not immune to that. But then RAF was exacerbated by the fact that the laws were not reformed. So we need to reform them because it's 30 years later. So earlier on, the Deputy Minister is now confirming that your submission in terms of everything that you are highlighting, because if you look at the two bills, there is fundamental differences that are there. And some of them do not, what they are trying to propose does not change the status quo. But what you tried to propose, or rather what you are proposing, seeks to change the status quo and tighten the belt in terms of servicing the right person that must be serviced. Given that, one thing we should also look into is to transform ourselves, especially as the entity of RAF. So earlier on, the CEO says we are servicing our people who have tried to work, but the problem is that there are very poor people that are in the far-flung areas. They don't get this communication of things changing, of come and lay your claim yourself, what documents are outstanding and all of that. But we need to be innovative in terms of, I understand you are having budget constraints and all of that, but we need to look into a model that's gonna work in terms of ensuring that as much as our offices are in bigger towns, but there must be some way of either mobiles that will go to smaller towns on certain days of the month to make sure that there is a closer reach for the people that you can't find. Because the last time we were at your offices, there was a stack of claims that these are the claims we are trying to process, but we can't find them. You also said that again today. However, how far do we go in order to find the people? There are addresses. We can't be writing to them in many cases because we have a problem with the post office. There are no phone numbers. Some phone numbers are not reachable. So our drive shows must not end at the big towns. Maingaye Mthatha, kaye Eastern Cape, kaye KZN, iphelele ePietermaritzburg naseDurban. Ingafiki eNquthu, ingafiki eQwaqwa. So we have to be where the people are so that this cry we all receive as members of parliament that, but URAF seems to be working, however, AMI claim was never paid. So those kind of complaints, we should find a way of averting them. Now, the second thing is, there's an interesting observation you've, in fact, finding. It's not even an observation. It's a finding by yourself as well as the AG that you used to have 58.5% of cases of claim that are opposed in courts. And you have taken that and turned it around by settling with people directly, and you are now sitting at 81.9% when you are doing it with the people. Now there is a question mark there. It's part and parcel of this abuse by the lawyers. That it looks like people don't want to go to court, but someone is driving them to court. And you have quickly changed the picture and settled with the people immediately. But what are those aspects that you have identified so that when we meet with them, we ask, why do you do the following? Instead of doing the following. In terms of the staff members, so we just received a report from SIU, I think last month or 2 months ago, on the medical legal issues, and this is not different to that. But there's always insiders assisting the outsiders in the process. Have we identified the insiders? Because even if we reform the law, we will go and deal with all these other aspects of regulations and everything. If we still have rotten apples inside, we're not going to correct anything because the rotten apples will multiply. There's always one person who's going to find a way around the system and use it for their benefit. But the ones that exist now, let's find them, let's deal with them, and let's get a list of who was dealt with and where are those people, because many people must pay that money back. Thank you very much for the savings on the medical cost as well as the legal cost, because this then gets to show us that money goes to the people and we pay more people than to pay unnecessary services. But here is a problem in the medical aspect of this. There are thresholds in anything, and I think, Nani, you do have your own threshold in terms of if you are a hospital, if you are Netcare and you had picked up a person from an accident and they had broken a finger, we expect you to invoice us R5. And then you go to another hospital, invoices you R50. how strict are we in that area? Because that's another area which, as much as we want to save, we are still going to have a problem of certain hospitals that will say, I will not take you, die here on the road, because RAF is not gonna pay me. So we should not have unintended consequences of what we are trying to correct. Because they must be aware, all of them, we should not have a certain hospital invoicing RAF a certain amount, gets paid, but then another hospital that will invoice RAF, then it doesn't get paid. Do we have a uniform amount that's transversal for everyone and which applies to each and every South African, whether you have a medical aid or not? Then the funding model. In terms of the funding model, this goes to the accounting standards. Board Chair, please respond to what the executive had written to you in terms of having a sit down with AG. Because it's 30 years down the line. And of course now there are new realizations, there are new ideas, and there are new realities that we are facing. Therefore, the law cannot remain the same. So yourselves and AG at some point, this tug of war must end. Sit down and look into it. I know in terms of treasury, there is some room for you to utilize in terms of the IPSAs that you are using. However, if AG says, but there is a standard accounting, the accounting standard that we are utilizing, therefore you can't use that alternative, even though the alternative is available for you to utilize in a space within which you are working and how you are paying the claims. But that sit down must take place, because as parliamentarians, we must change that law if it has to be changed and accommodate the near future people that needs to be accommodated. Which means, Chair, ourselves as a scope, I think we must have a recommendation as well. I know there is a mediation committee that is being established, but we can't have a situation where what you were saying earlier on, we adopt midterm, then we adopt an APP that says something else, then AG says something else, and then we agree with another entity on this, because another entity is going to come and mimic what you are saying, but then we will not be agreeing on the basis of their functions. So we need to find a common ground as parliamentarians on the issues of this nature. It can't be that the 6th Parliament was dealing with this. Now the 7th Parliament still can't have a resolution, and we need to have a recommendation to the House in terms of this. Something has to be done and something has to be changed, because we also have a fiduciary duty to make sure that the laws accommodate our people. Last thing is, alcohol is our problem in South Africa, shame. That one, I don't know how you're going to deal with, but this thing of paying drunkards, that kill our people. Even with COVID, many hospitals could not deal with patients that were dying of COVID because people were just drunk, driving drunk, killing people. There were more drunken driving accidents in hospitals than COVID patients. And then you can then imagine how many claims come in a day as a result of drunken driving. And then that same drunken driver is expected to be paid when the law clearly says you can't drink and drive. Yet the same law says, pay me even if I'm the one that caused an accident because I was drinking. So there are things that should take a priority in everything that we are doing, because there are things that we need to really cut them off immediately. I don't know how you are going to do it, Board Chair, but you need to sit down with the executive. Some of the things need to be removed as a responsibility of RAF, and we should be able to be assisting you. Thank you, Chair.
Incidentally, Honorable Member, if you and I make an insurance claim and we were drinking at the time that we were driving, the insurance doesn't pay. Just as a as a point. So I just want to ask a question because the question I have may be irrelevant if I get an answer in respect, because I'm also going to record my own questions. So as I understand, you don't have a panel of attorneys. Would that be correct? There's no longer a panel of attorneys that you use? No, I just want to know, because otherwise my question is irrelevant.
We do have a panel of attorney, corporate panel.
Okay, so may I just, and I may have missed it, either in writing it to you ahead of the committee or it was just, there was a mistake on your part. I asked for 2 lists. One, the Debrolios of this world. The second list was the attorneys that you pay. The attorneys that represent the Road Accident Fund. We wanted that information. If that was missed, can we please help each other? And I understand that may not have all the detail, but if you do, that would be helpful. If you don't, can we please have that for next time? So that was the one question I have. So it's a request. The question I have is, I'm assuming that there was, I understand that there was a period in which you had dismissed the panel, which is your prerogative. And I also understand that you instead used the state attorney, again your prerogative to do so. I don't think there's anything inherently wrong with that. Can I ask the following questions? Have you quantified the delays in the processing of claims and attendance to court matters? Quantified them by volume? And also quantified them by the number of default judgments against the RAFs? In other words, the total amount of money that the Road Accident Fund had to pay to claimants as a result of not having anyone representing the Road Accident Fund in the court proceedings, because that's the one thing. So that's the one question I have. The second question I have relates to what we discussed earlier on about the vetting of officials. I understand that your chief investment officer used to work for the city of Johannesburg, and he left the city of Johannesburg following the presentation of disciplinary charges against him, which pertained to gross negligence, misconduct involving the withdrawal of some 2.6 billion rand, which was then put in the trust of Regiment's Capital, who featured significantly in the Commission on State Capture. Were you aware of that reality? Have you had a discussion with your acting chief investment officer in this regard? And are you comfortable that a person who left under those circumstances should also be put in charge of the Road Accident Fund's finances? So that's the second last question I have. The final question I have for now, because we said the SIU issues we will litigate when the SIU talks to those issues, pertains to, so I just want to understand, it may be a misunderstanding on my part, that your investment income, your investment, interest and investment income has grown significantly. I don't have the number at the top of my head, but it's somewhere in the order of 600 million and above. However, your cash and cash equivalents at the end of the financial year appear to be where they need to be. I just want comfort. I just want comfort that this is not due to delays in the payment of claims and therefore the cash accumulates as a result. I'm then going to make a comment, which is that personally, I really appreciate the funding issues that the Road Accident Fund has. As I said, in South Africa, we want to deal with one part of the problem and not deal with other parts of the problem. And that the Road Accident Fund is in an impossible situation financially. Even when the accounting standard issues are resolved, you are still going to have these difficulties because there are just too many people dying on the roads. The manner in which the claims, people qualify for claims, and it's tightening up. I'm not going to relitigate the issue. So I want to say that it's clear that the Deputy Minister and the Minister have a responsibility to place before Parliament a piece of legislation that responds to all of these issues. And we will take up the Deputy Minister on his coming before the committee to explain how these proposals are going to work to resolve that issue. So we are not unsympathetic. We're not unsympathetic to you getting less money from SARS because the road levy has once again not been sympathetic to all of that. And I want to place that on record, that we recognize that the entity operates under challenging conditions. But could you then deal with the questions that I've asked and also give me comfort around the cash and cash equivalence issue vis-a-vis the interest and investment income? Thank you.
No, sorry, Chair, I just forgot to also request that, similar to the list of the lawyers, can we get the hospitals that also send fraudulent claims to you, especially the top 10 and the amounts? Thank you.
Chair, over to you and your team.
Thank you very much, Chairperson, and the members that have asked questions and comments. Let me start by thanking yourself and the members for understanding the challenges that are facing this organization and us as the leadership, as well as supporting us, because we don't take that for granted. We appreciate that support. Let me answer the questions that were directly directed to myself, and then the CEO will deal with the rest. I think the first one was around the engagement with AG. Honorable Mente, you said to us, are we still engaging the AG, because this matter started in the 6th administration and now we are still wrestling with it and there is no solution. Let me start by saying and give you comfort that this matter, we are still dealing with it as a board. What we've done is that we are continuously communicating with the AG. In fact, we've tasked the audit committee to actually engage with the Auditor General, the ASB, which is the Accounting Standards Board, as well as the National Treasury on the Accounting General. We're doing this because we're looking for a technical solution. What we're saying is that as soon as we get a technical solution, then we have reasons to actually consider the withdrawal of the court case. Because the reason why the matter hasn't been resolved is that we haven't received a technical solution and the courts haven't decided on the matter. But last year, there was a process started by the ASB in drafting a relevant social benefit standard. And I think the matter went to public comment, and we were very excited, hoping that we're going to have a technical solution on the table. And as soon as that standard is finalized, then we have more than sufficient reasons to relook at the current matter, because then we will have a technical solution that will do a relevant accounting standard to deal with the matter. So what we would like to request is that we do need political support to even bring standard setting boards, to this committee to just highlight the importance of finalizing this process. Because the Auditor General, in their responses, they're basically saying that they are auditors. They can't play both roles. They don't actually determine the standards. They will give you an audit finding and give you recommendation on what should be in place based obviously on the facts that are before them, but they will not actually prescribe and then audit themselves. So they've been referring us to the ASB to say, have a discussion because they are the ones responsible to set the standards. So in a nutshell, Honorable Chair and Honorable Members, as soon as we get a relevant social benefit standard, we don't have to wait for the court decision. We will withdraw the matter, and then because obviously we will have a technical solution on the table. But the important part is we are still engaging with all the technical professional bodies that are affected in this matter. We will not stop as a board because every time we come here, Chair, I always worry about this matter coming up. Irrespective of what's on the agenda, we know that we're going to spend more time on this matter. So as a board, we don't appreciate or undermine the importance of this matter, and it keeps us awake at night. So we will not be at rest until this matter is resolved. But we need your support on fast-tracking the standard because we know that work has been done. I mean, if they had an exposure draft, that means that the standard is actually in draft format that could be finalized as soon as possible. And then the other matter that was raised to myself was the fact that we've been here for almost 2 terms, and do we believe that there's been improvements, significant improvements within this organization? The answer would be yes, and we've presented to this committee for 5 years since we started the turnaround strategy. So to summarize, when we started, the RAF was facing a day zero in the sense that we were running out of funds. And I remember the first year when we went towards the audit, we had to go to the department to ask for a letter of comfort to actually back up the liquidity as well as the solvency issue. And from then, when we started looking at the efficiencies and within our operations, we started making some inroads in creating and also having funds that as a result of inefficiencies on the system. We are currently paying more claims than when we started. We're paying 90% more claims than the previous dispensation. And we've also paid 24 billion, reduced 24 billion rand in legal costs in the past 4 years. And I think that number is increasing as we're speaking. But I think above all that, we are basically paying people that are poor, because we also are making sure that young people that are below the age of 16, we fast track those claimants. So we are really coming close to the needs of the poor in this country. And lastly, Chair, I just want to say that, sorry, I'm just looking. Yes, the road accident fund bill and its withdrawal. We really need to do a proper reconciliation, because the road accident fund bill was really to ensure the future sustainability of this organization. So for us now having to deal with reviewing our strategy to try and deal with it, the main source of income that was going to be created out of this process was the payment of our claims in installments. So that has to be basically included in the current RAPS bill, and also trying to taking out the dependence on lawyers in terms of processing the claims. That is also another fundamental principle that needs to be transferred into the current bill and the changes. And also the issues about standardizing our rates. I mean, it's very important, because any medical scheme they always have medical tariffs, and we have already started working on that, and the tariff have been calculated, and I think it's one of the matters that are still sitting with the department. So there's a number of matters that need to be reconciled between the two bills. That is why we've requested more time to actually reconcile and work on that. So I will now hand over to the CEO to deal with the operational matters.
No, thanks very much, Chair. I'm gonna start and go in that order from Honorable Isaac, and we'll then go to the rest. The disciplinary actions for irregular expenditure, I think that is done and quite articulated in our financial statements, but we can, Chair, make that available to you once we leave here, so that we save the time. But we'll give you what we have done, who was charged for what in terms of irregular expenditure. We do it in line with the National Treasury prescripts, so we'll do that. Other costs related to claims payments, there are legal costs, but there are also costs of medical experts. And I think we spend a lot of money on medical experts. To lodge a claim at RAF, you probably need 7 medical experts, or that. Different medical experts giving different opinions of this thing and making assessments. And once you have paid them as a claimant, you are allowed to come to us to claim that money back. So that's the claims, and this is what we have been trying to actually reduce. To give you an example, I think it was last week, I got a call from an individual who said to me that the attended doctor at the hospital was charging 8,000 to do an assessment. You can imagine, for someone who does not have any money, it means they will never be able to lodge a claim without actually having to pay the 8,000. That area is also not regulated. It's one of the costs that we'll then pay at the end. We'll come back on the consulting fees and we'll do the breakdown. So it's 1 and 3 that we will come back to and do the breakdown and show you the increase. But I think the biggest part of that would have been also on issues around marketing and comms when it comes to consulting, because we don't really use a lot of consultants, as it were. Are you playing a dual role? Absolutely, I'm playing a dual role. The worst thing that can ever happen to a person is simply because, as I said, we went to market 3 times. We couldn't get anyone, so I'm doing that work as well, which is a lot of work that we do. I can assure you that I'm not getting any cent for that work that I'm doing as a chief claims officer. Specialist security officer from Transnet. Chair, the RAF has got about 3,000 employees. I wouldn't know at any one given point who gets appointed from where and all that. I mean, we will come back to you. We'll try to check what is a specialist security officer. I am not quite sure. If we get that information, Chair, we'll come back to you and certainly report on it.
Can I try and assist you,
Yes.
Mr. Litswalo? Was it, which Honorable Esak, do you have a name to assist Mr. Litswalo here, or a specific role? I don't want us to go around in circles here.
Chair, no, I don't have a name. It's what I've read in the report. So this is why I'm asking the question, but they're welcome to write to us and respond in writing as to what is this duty of, what does the specialist safety officer do? That was my question.
Which report is this? I just want to assist them to, which report is this?
It is in our own report, Chair.
Or the briefing document
Yes,
that we got.
yes.
Okay, Mr. Lutalo, we will assist you. So we'll consult the document and give you the specifics, so you can move on from it.
Thanks so much, Chair. That would be very helpful. The 246 employees lost, I'm not so sure, probably this is attrition. It will be made of people that are either dismissed or disciplined under disciplinary actions. And the second part would be people that would normally just resign. And of course, there will be people that will retire. Impact of business continuity, very minimal to the extent that it is about what is called institutional knowledge. We have changed the RAF model quite significantly, and consequently issues around that are not an issue. The issue is the numbers when it comes to the area of ops. Because of course when you lose someone who was processing claims, you're going to take a while before you fill that position. We feel that as it were under those circumstances. But Chair, as Honorable Mientes referred, we also can't keep people that are doing wrong things simply because we are going to struggle with that. So I think to that extent we are expected even by Parliament to make consequence management have a meaning, and to that extent we do from time to time discharge people who are found to be, as I said, it's progressive discipline, but it depends the kind of issues that some. So on issues of fraud, it's a non-negotiable, and we do send people out of the organization. Honorable Maduna,
Excuse me?
It's me, Chair. That was my question. I have a request. The CEO is not certain about the question. Is it possible that you can respond to the question, because 246 employees that were dished out, and you can't even remember which one were those. You are now assuming that it might be this and that and that. I would rather we get something in writing on that one as well. You will have to assist because it's on our briefing document. Thank you, Chair.
So can I assist in this way, Mr. Litswalo, and that's for the response in writing, so that you can give us more specific information. So basically, just share with us what your normal annual turnover per year is, right? And this is now in reference, this question is in reference to the financial year under review, right? So just tell us what your normal staff turnover is, let's say over a 3-year period, right? So that will assist us to see if there are any anomalies. Secondly, can you then just tell us of the departures that you've had? Just give us the levels at which those have been. You don't need to give us names or anything like that. Just say, you know, at executive level, mid-management, etc. That's what you've had. So please just finish that to the committee. I think that will assist Honorable Non-Danger, because we can then see it in context whether it's a problem or not. All right, thanks.
No, thanks, Chair. That would be very helpful. I'll do that. Honorable Maduna was referring to litigation costs and issues around system abuse. I mean, this is a big problem for us, and I don't think that it's a RAF specific issue. I think any social benefit scheme has got it. And even insurers have got that problem of people that are claiming. Medical aids are even the worst of this abuse, fraud abuse and all that we look at. So we do deal with these matters from time to time. When do the matters get concluded in forensic audit? It depends.
Honorable members.
It depends, Chair, on the intensity of the matter and how it is. Some matters in the forensic include police, which ones take longer. Matters that are civil in nature, we do fast track them and quite quickly deal with them. So it depends on the, but there are targets for the forensic unit on when to conclude these matters, for as long as those matters are not going to be dealt with external experts. Some of them we finish, then we hand over to the LPC, some we hand over to the SIU as it would be the case, as they are still with us now. Inconsistent judgments. And of course, charging people an amount that is up. I mean, I don't believe that 25% of someone's earnings is reasonable. It is lawful. I don't know how ethical it is. I mean, to take a quarter of someone's earnings to help them access the money, I don't think that is but it's lawful as we sit here today. Inconsistent judgment, well, they are there. That's why we appeal them half the time. I don't want to be judiciary bashing. That's the last thing I want to do. If you've got a problem, Chair, you might invite them here for them to answer for themselves. If people are brave enough to go that route. And as I say, there are judgments that we are unhappy with, and when we find those judgments, we appeal them, we go to the highest courts in the land, as it were, because our view is that we want to believe that it can't be something that people do deliberately. We say they err. So they have erred, so we take this thing there so that other people can actually look at it. Then there is about, Honorable Skosana spoke about issues where we work together with SIU on this 317 million, Chair. But the total amount was in the region of 1.2 billion of duplicate payments. We only gave them 340. We had collected most of that money as it were. We would love to see this thing, Chair. I'm tempted to name the bank, but I'm sure SIU can do a better job in naming the bank. Let me leave it to them so that they can, if they want, Chair, I can come and name the bank. There is no problem at all. I'm just saying that they are dealing with it and all that. That bank owes us money that was paid in duplicates. That bank must bring back this money. Like we are following Discovery, like we are following Bonitas for our money. Now, Honorable Miente talks about, of course, I mean, I think the issue for us is the amendment bill being withdrawn means steps backwards in a sense, but it's a policy matter. It's not something that we ourselves, you'd know that we just implement what is there. So that is a discussion we are having. Of course, we would have preferred for it not to be, but I mean, the horse has already bolted. So the issue around outreach, it's a difficult one, but we are trying to manage it. Community radio stations, trying to go there on our own. We've got a thing called a wellness bus that does go in those areas. We are trying to expand that for us to go and service our people there. But you would have seen what lawyers do. When we start contacting their claimants directly, they write threatening letters. I'm sure people would have seen in social media someone threatening us, don't contact our people. We don't care, Chair, we are going to do it. Because there's nothing unlawful about it. Saying to you, you came to us and you put in a claim and you never came back and we are looking for you, can't be unlawful. Let's test that in court. Let's see whether the court will say, because they threaten us with court challenges, cease and desist. We are not going to cease and desist contacting people to say, come and get your claims. Because half the time we realize that we actually have paid and they are not aware. Or we are trying to get more information and the people are not being told, but the lawyers are telling us something different. So we're going to do that. They will have to take us to court. We'll then battle it out in the interest of making sure that we pay the claimants. We have been trying to settle these matters. Of course, there are staff members inside, as it would indicate in the 200 and some odd. There would be others that we have discharged for that reason. It's not easy to pick up people. I mean, that they do this thing, they do it with lawyers, sometimes they do it with medical institutions. It's a very difficult thing. You need a list of medical and we can provide that list, Chair, as it were. Do we have thresholds? Yeah, this is one of the areas that is quite frustrating because we really moved to a point of getting what we call medical tariffs for RAF, and they were challenged. We went to court. Everything we do, we change in this place goes to court. So we must get that. So we went to court. We had this thing, and we had changes of the medical tariffs, and some of these medical tariffs are still sitting with the department. We are still waiting for them to give us the approved medical tariffs, and as they take more time, time moves, and it's quite difficult to deal with those matters. Chair, I think you need to also call the Public Sector Classifications Committee to this committee. You need to call the ASB to this committee. You also need to call the Accountant General to this committee so that certain things are clarified. We tried. We have been trying to get these meetings and all that. It becomes difficult when it's us that are asking because they need to account to Parliament. Probably they would come and do that because you can write a letter. The letter takes 2 months to be responded to. Then it's all those things, and we try to engage. And our aim is that we engage. Okay, the issue around alcohol. Okay, we think that the issue around the drinking and driving is a problem. Drinking and walking is worse because when a person an enforcer, a policeman meets a guy that is drunk and walking, what does he do? Arrest him, and what do you do? Because he does not have a license, you don't know who he is. He could easily be anyone. So that is the biggest problem. And I think COVID has showed us that the alcohol industry is just not paying its fair costs, share of the externalities it causes. And we believe very strongly that there must be an alcohol levy that goes to funding the RAF. Because 68%, I mean, the last report that was done by Medical Research Council indicated that 68% of all those that die on our road die drunk, whether pedestrian, whether passenger, whether, driver. So that's the reality. And the question is, do people drink responsibly in South Africa? And then they say drink responsibly, but they sell you more than 2 beers, and it takes you 2 beers to be above the limit. So ours is that they must pay.
Sorry, may I also say that I've had a look at the carton of Ijuba. So the carton says, don't drink and walk. It does. I felt some type of way. There's classism going on there. But if you look at the carton, it doesn't say don't drink and drive. It says don't drink and walk. Sorry for that.
There must be a reason, Chair. I think it's targeted. Chair, the issue around, we'll give you the lists, the ones that indicate the plaintiff attorneys that we pay, and the ones that represent us as in the corporate panel of the RAF. We never dismissed any panel, Chair. We keep on explaining this. The contract came to an end by a fraction of time. We did not renew it. It cost us 3.8 billion a year, that contract. And we did that because we simply said, RAF cannot afford this. They took it all the way to the Constitutional Court, Chair, trying to retain this. And we lost in the North Gauteng High Court, but SCA, we prevailed, and we prevailed in the Constitutional Court. So the aim was, the fact that we have got a defense panel suggests that we want to litigate. We want to settle. So that's the aim. And we were aligning ourselves, Chair, with the judgment by Judge Petersman called Ketsekele versus the RAF. I think it's going to be important that we send it to the committee, because this will tell you this aspect. But we will also send you the research report that was done by Professor Henny Klopper about us 99.6% of the time settling these matters in front of the court when we have spent a lot of money litigating them for the sake of it. So we decided that is not the case. Now, you balance the 24 billion we have saved, you must balance it with other things that you need to balance on the other side. So yes, we'll give you the number of default judgment, Chair, but the reality is this: even during the time of this thing, we had default judgments. As I said, it cost us 10.6 billion. 6.8 billion of that was being spent on plaintiff attorneys. So 3.8 was defense, 6.8 was that. Add them together, 10.6 billion we're spending every year. We are now spending 3 billion. Now,
So, sorry, may I ask again? So, when you say 3.8, because you helped us with a slide there with the top 10. I think we'd asked for the top 10, where there's DiBrolio and brothers and sisters. So, are you saying that that was the total amount? You said 6 point something odd billion.
6.8 billion.
6.8
on
billion
the, yeah,
was only for legal costs.
absolutely.
What is the amount now?
3 billion altogether included.
Okay, all right.
Which is why we are saying 24 billion over 4 years.
Okay, all right.
Yeah, so the vetting of officials, Chair, we do vet officials. As we said earlier on when we came here, there are officials that are expected to be vetted, and there are officials that are, what do you call it, when you just run a process of checking whether those people have got the screening. Yes, there is a screening part that is done. On the issue around the official you are referring to, we ran this process and we did touch base at the time with the city of Joburg. The view was that there were no charges. The charges were dropped. There were issues. They then had an agreement. Did we look at the disciplinary charges themselves? No, we didn't go to each and every disciplinary and say these were the issues. No, that was not done. But that is the process of screening. We screened, we checked for everything, and everything looked okay from where we're sitting.
So I just want for clarity. So the city of Johannesburg decided that the charges were no longer necessary. In other words, there was no case, or was there a mutual separation between them?
What we know, Chair, is that there were no charges. So we don't know whether, we know that there was charges before, that's what we are told, and that those charges were dropped. So we don't know to the extent that they are saying they are no longer charges or what, because there was an agreement between the two, if we understand it.
No, I don't, but I'm mindful of time.
Yeah, but Chair, he's here, he can answer for himself.
No. So I'm going to provide some help because the House is sitting at 2. I don't want to be unfair to you by hurrying up this conversation. That's all I'm saying. So when we meet again in that interaction I referred to, we will then ventilate this matter properly. Okay, because there is something in the language, the charges can no longer exist because a person has left the organization, etc. So, and it's not, I don't think it's necessary for you to get into that detail now, except to say that there were charges relating to this. The official left the city of Johannesburg. You have looked at the circumstances and you were comfortable that you could engage this person. Let me just offer some advice, Mr. Litzwal. Please tighten up your due diligence when you hire, because you should not be in this position where you're having to answer this question, right? So that's all I'm going to say, because we interact with other agencies. You are not the only one. I'm just offering this advice without getting into detail. Please tighten your due diligence, Chair, as well. Just do that so that you don't need to deal with these issues. We need to litigate this issue in detail, and we will.
We'll litigate this issue, Chair. But you know, I was once accused of paying myself. So we must be mindful of those issues as well. But we'll ventilate it. The investment income, Chair, comes from, in the main, it comes from in the main, the what we call the investment account, where we keep money in a call account for some time. And Chair, I'm not going to add much more of where this money is and how we keep that money. For this reason, Chair, we have had a lot of lawyers running around looking for this money because they want to attach it. So for that reason, I can see the idea of, okay, where do you put the money for how long, where do you move it and all that. I don't think that will be in the best interest of the RAF, Chair, to do that, because we will have a situation where one day we sit here and all the money has been attached in one way or another. So we know that there has been questions that are asked about the specificity of how we deal with these monies and what we invest and what, and the rationale of it in the main from a lot of other people that are watching this is to actually know where this money is so that they can simply go and attach it.
Sorry, Mr. Lutsolo, so that was not my question, but we can deal with it next time.
Yeah.
What I simply wanted comfort.
Yes.
So in order to earn north of 600 million a year on a call account, you need to have a running cash balance of between 9 and 11 billion for much of the year.
Yes, sir.
Right. My question to you, my request, I wasn't even asking you a question. Is just give me the comfort. I don't want to know where the money is. It's not relevant.
Okay.
Give the committee the comfort that what is going on here is not a case where, for whatever reason, cash accumulates in the bank instead of being processed out to pay claims. That's my only thing. I never asked for you to say where it is, and I was saying, please provide me with comfort, because your cash and cash equivalents at the end of the financial year are much lower, which tells me that your claims process is probably like a bell curve in a sense. So you start off low, it goes like this, it plateaus, and then it drops significantly towards the end of the year. Right. So I'm saying at the point at which the bell goes up and it plateaus at the top, at the plateau, you're not having a case where there's lots of cash sitting in the bank, accumulating interest, and then in the last 3 months, before the end of the financial year, you then process the claims faster so that you end up with a smaller cash and cash equivalents. I'm having to explain this now, but I don't want to know where the money is.
No, that's exactly what we do, Chair. That's exactly what we do. We raise it up and we accelerate it, and you'll see it in this way. So we have got 180 days within which we must pay someone, so we keep that in line with the 180 days. Towards the end, because then we realize it's at a time when we know that we have got money and then the financial year end. We drop that thing below the 180 days. There was a time we reached about 45. Because what we are doing, we are making sure that we meet the requirement in terms of the 180 days so that we don't have attachments. But towards the end, because we know that we have got all that cash, we can then start paying. So you will see, as I said to you, in the third quarter, towards the fourth quarter, that's when we start. This time we did not start because SARS told us that there is 5.1 billion that might be ducked out. If it got ducked out, it meant we will not have any cash to maintain that 180 days. So we kept it right there. But towards the end, we do reduce that amount at an accelerated pace, and we reduce 180 for as long as we have got enough cash to be able to carry us through to the next financial year, and we build again. That's exactly what we do. So the issue, Chair, around, I think I've dealt with that. Then the last issue that we raised was about comments on legislation and policy, Chair. We thank you, Chair, for the support, because I think it's important that people understand what we do and what we do these things. But what we want to emphasize is the fact that without any legislative changes, in fact, I don't think we have got any other, the next 2 years are gonna be very difficult for us. Because for as long as we can't pay in installments, the court has taken a view that this 180 days is not gonna be there anymore if we don't bring any changes in legislation, meaning that immediately people get court orders or we settle with them, all those matters will immediately be due and payable. That would mean the attachments are going to increase quite exponentially. And that's where we are as we sit here today. So when we come back in the next 3 months or so, we might be talking a totally different thing, given whether we end up having with what the court has instructed us to do, which is bring regulations to regulate that 180 days. And if we can't have those regulations, Chair, we will do what Honorable Madlala was saying, which is come to you with a begging bowl and say, please give us the money. Because if we don't get that assistance, then we are going to be defeated. Thank you.
Now, what we'll do is we'll have Honorable My Money of Appropriations present so that we can tap into the money. So, colleagues, honorable members, I want to thank you. I want to thank you, Chair. I want to thank you, Chief Executive of the RAF, Mr. Litsolo, for being here today. So what we'll do for next time is that we will be very specific again in terms of what we'd like to discuss between us. As I said, we won't keep you here too often and unnecessarily. So we'll try and coordinate such that the dates minimize your traveling time between Cape Town and Pretoria. Or Tswane, so that we give you as much time to do the work that you're supposed to do every day as possible. But like we did this time, we will try and be more helpful in terms of what we want to know from you, so that you can prepare accordingly. But thank you again for responding quickly to the letter that we sent after the meeting with the Auditor General. Members, I'm sorry, we literally have to sprint to the house. My apologies, but thank you very much, and all of you go well, and members of the SIU and the AG team, thank you.
Thank you, Chair.
Chair, akusidiscover kune-permit nayo la yasiceda.
Apparently, Parliament, colleagues, Parliament also made provision for some food downstairs, so please.